Serial number 10, Lordship, short accommodation. Serial number 10, my lord. Short accommodation.
We'll go after.
My lord, can I make one submission in that matter? My lord, we have considered their application. My lord, but the order has not been released.
So then, madam, it will not survive.
I'm sorry, my lord.
Tomorrow at 2:30.
Very well.
Tomorrow at 2. 10. 10 is tomorrow at 2. Tomorrow is which date? 4.
Serial number 40, your lordship.
40. 40.
Connected, I appear for accused, my lord. Connected.
It will go to 23rd of June. As request. Can go to 23rd of
Number 40.
4. Contempt and people.
My lord, serial number 44 and 102 are connected.
My lord, for the petition of my lord.
30.
30. The serial is answered today. My lord may be placed to proceed any day in the next week.
2020 PAS. What is it about?
Regarding the slum declaration.
Liar.
My lord, it's for rehabilitation of 122 families, my lord, who had been evicted from the forest area. We have filed an affidavit. Now an impleading application has been filed by a person who says he's the owner of, my lord, that extent of land which we have, my lord, reserved for rehabilitation.
Bleeding.
Impleading application is filed. IA-1 of 2025. We had filed an affidavit on 1/2/2022.
So the order was passed on 9/7/21.
Yes,
Asking you to reconsider. Reconsider means
my lord, based on which we have filed an affidavit.
retransfer.
Yes, that we have done. We filed an affidavit on 1/2/2022. My lord, now he files an application saying that he is the owner of the 2.10 acres of land.
You can independently execute. Who is it?
And for the petition.
You are for the petition. Who is for the impleading application?
My lord, B.S. Sudhindra.
So 7th,
May be taken up any date.
7th at 2:30.
Serial number 17, your lordship. Serial number 17 and 17.2, your lordship. Serial number 17 and 17.2. 17.2, I have not yet received the writ appeal copies, your lordship. I've informed I'm for the respondent. I've informed the appellant. They said they'll be serving me in a day or two. In 17.2, I have not received the writ appeal copy. I have not received. I've informed the appellant also for that matter. Told me that in a couple of days they'll be serving me the copy of the writ appeal in 17.2.
Which matter you are mentioning, what you are. Yes.
You know, I'm
Serial number
appearing for-
49 and 80, my lords, it's a
49
contempt.
and
49 and serial number 80, my lords.
80.
My lords, both are connected matter before this court. The subject matter of this contempt petition is pending before the Honorable Apex Court, my lord. The matter has been listed there in 8/4/2025. I'm producing the order
You
copy.
go up
Please, madam.
in view of the state, in view of the state, in view of the submission made by learned advocate.
Sinchana. Accused number 2, my lords. I'm appearing for accused number 2.
Attention, MR,
Please.
that the subject matter of the contempt petition is pending before the honorable. In special leave, to appeal number 1780/2024. The present proceedings are adjourned to
Please, ma'am.
which date?
And the June, my lords.
July, 8th of July.
Please.
My lord, serial number 95,
leave,
my
my
lord.
lords.
I am for the petitioner, 95, my lord. I filed a writ appeal for the expedite of MC case, my lord. My lord, the notice is not served, my lord. So kindly have it in the month of June, my lord. Sir,
So both, same order. 49, 80. EP is also, same order.
that's 95, my lord. I'm for the petitioner, my lord. I filed a writ appeal regarding the expedite of the MC proceedings, my lord. The notice is not served. So kindly have it after vacation in the month of June, my lord.
As requested by learned appellants, stand over to 25th of June.
Serial number.
Much obliged.
17, serial number 70. I'm for the appellant.
Serial number 90, my lords, 90. Service is not complete. 9090.1.
Since notice is awaited, since service of notice is awaited, stand over to 24th of April.
My lords,
Obliged.
one
Obliged.
my request for listing during the next week. The Learned single judge, my lords, had dismissed the writ petition. My lords, where a mandamus was sought for. Police Association, my lords, has filed a representation before the government, seeking for, my lords, reduction of the commutation amount. Learned single,
Who has filed?
the Police Association of the retired official. Learned single judge, my lord, to dismiss the writ petition, saying go before the alternative remedy. It's a petition for, my lords, for mandamus, for only consideration of representation.
What do you want?
Please, my lord.
What do you want?
The lordship may kindly consider having it next week, filing a memo.
The first.
The serial number 8.
Matter for preliminary hearing, Lordship, the another single judge, Lordship, dismissed the writ petition filed by the petitioner, Lordship, by holding that, Lordship, already realty matter has been disposed, Lordship. Lordship, the same property has been put in position of the appellant's, Lordship.
Go in June, 9th of June, 10th of June.
84.1.
55.
50,
55. 555.
double five, yes.
It is a week then.
No week, then you go after vacation, 20th June, as requested.
Serial number 112.
54,
4.1 for the petitioner, my lords.
yes.
It may be taken up any day in the next week, my lord. Due to the inconvenience that the senior is unwell, we couldn't take the submissions today.
84,
4.1.
other side is informed.
Let serial numbers.
84, also keep it 7, 7, 7,
Let serial numbers.
will be 7. 7, 4.
Serial number 17.2, my lords. I'm for the appellant, my lord. Senior is out of station, my lords. It may be taken up after 2 weeks.
Serial
My lord.
number?
17.2. Respondent is present, my lords. We'll serve the copy and we'll come back.
That was mentioned.
Yes,
You want after vacation,
yes, ma'am.
24th of June.
Serial number 112, my lord. I may be permitted to withdraw, my lord.
Serial number?
112, my lord. 112.
My lords, I'm making a memo before this honorable court regarding another case, my lords. In DC court, it has been, the order has been passed against, in our favor, my lords. In writ petition, the petitioner has taken, the respondent has taken the order in their favor, my lords. In the meantime, they're trying to alienate the land, my lords. So we have filed writ appeal, my lords. May be taken up next week, my lords.
24th of June. 24th of June.
Serial number 112, my lord. I may be permitted to withdraw, my lord. 2. Already filed memo, my lord.
Honored Advocate Mr. Vasanta.
Please, please.
For the appellant seeks permission to withdraw the appeal. Permission is granted, the appeal stands disposed of as withdrawn. All interlocutory applications will not survive in the withdrawal of.
Great.
Serial number 113, my lords, for the complainant. 230, madam. Says same that it may be taken up in 113, my lord, for the complainant, my lords. Says that it may be taken up next week only, my lord, any day when my lord may be pleased.
Then why it is kept at 2:30?
My lords,
It is kept in the after recess. Why it is kept?
for the order.
The matter is adjourned. Mediation.
Let you be here.
I'll be there, but for the senior is
We'll see if senior is required, we'll grant it. But you be here.
grateful.
My lord, serial number 33 and 33.
Lord, fresh matter, PIL, my lord. Fresh matter, my lord, PIL. My lord, the urgency is that one of the respondents is releasing effluents into the water. which is the only source to a village, and children are falling sick, my lords.
After vacation.
My lords, there's a grave urgency, my lords. Children are dying. 2 children have already died, my lords. 2 children have already died because it's the only source of water to the village.
Which will?
My lords, it's a village in Coorg, Etchur village, yes, my lords.
Lake in Pur.
Yes, the village in Coorg, and it has only one water source, my lord. There's only one water source, which is this river, and there's a RMC plant set up, my lord. Children are dying, my lord.
16.
Serial number 103, my lord. Serial number 103.
103.
103. 1 week time may be granted to comply the office objection, my lord. 1 week time.
After vacation. It will go after. As
Obliged.
requested by learning of parents, 10 over to 23rd June. This is for office objects.
Yes, my lord.
We'll pass the order. So again, come for that office. Serial number 102, 103. Office objects will be removed within 3 weeks, spelling with the appeal shall stand dismissed automatically or without without reference. Automatically without reference to or order.
My lords, this is a PIL that challenges cabinet rank extended to MLAs and seeks for the dismissal on grounds of them holding offices of profit, my lords.
Already there.
No, my lords, the state has filed its objections. May I request for it to be posted on 17th, my lords. My lords, the senior counsel engaged in this matter is based in New Delhi. He's arriving here on 17th for another matter. My lords, on the
Date must have been given.
No, my lords.
It can't happen. It's a pending matter.
Yes, my lords, date is not given.
It can't happen. Then file interim. Serial number 33. Which date is going to find out?
3570 of 20.
That office of profit matter.
Please, my lords.
Date must have been. It is not given.
PL respond number 8 without obtaining the license, bar license, opening the liquors of premises of school and college. Arsikere Taluk without obtaining the license, liquor shop open.
The liquor shop is open.
Oh,
Who is open?
without one of the respond number 8.
22nd. 22nd.
Tomorrow.
Tomorrow. And the serial number 33 and 35. 33 and 35, yes. I was requesting for short. So there is no short. 33 is what? 33 and 35 will go beyond vacation on 26th of June, as requested.
And serial number 10.
Yes,
Lord, serial number 14.
you want to mention?
Serial number 14, my lord.
14.
Kindly out on next week, my lord, some inconvenience. Next week, anything.
Next week will not be possible. We'll go now.
Which one?
Serial number
Let it be called up. We'll see.
Oh, that day we did.
10. 10.
If you say no, it will be a problem. But they are doing it. 20%.
For office object, we are granted time to remove the object. 2 weeks time.
Serial number 89, this is a PL on EST implementation issues in BPMP. This matter was filed in November 2024, not been admitted. This 89 number is difficult to come for hearing today. It's already 6 months have passed. I'm requesting for early hearing today.
We'll see if time permits.
Any
mention lord.
to sir?
Yes, Mr.
My lord, serial number 44 and 102. A similar matter is placed PIL on 7th 2:30. These are all connected matter. Can we post it on the same day, my lord?
Which one? 44.
7th 2:30.
No, not 2. 44 you want to post the 7?
44 and 102 both.
102 is under office objects. So what to be?
But that is also similar matter, my lord.
Yes. Date appeal number 160624 will listed with 10, whatever number. Next.
Seal number 1, Mr. Deepak Bhaskar.
But appear for the respondent, seal number 1.
So we'll dispose of.
Yes.
Short submission for your lordship can consider. One is that, but it's our case, that in the suit that we had filed, an interim order was passed on 26/12/2024. When we tried to bring this to the learned judge's attention, he would not take it on record saying that the order was already ready.
What is that?
But what has happened is essentially in this case, I have an interim order against them, they have an interim order against me now. I have it in a suit, they have it in the form of the section 9 interim order. So your lordship will therefore have to possibly request the commercial judge to hear the matter afresh without being influenced by this. That is one. Otherwise, my lord, but the other submission I made yesterday really stands, which is that the family members.
But what has actually transpired, Lord, is 6 months after facing the Section 9 petition, and when the matter was reserved for orders in the Section 9 petition, sometime in December, after that they institute the suit, Lord.
No, that's correct. But
For
the
6
point
months,
is that
for
the
6
Section 9
months,
petition is disclosed
they
and
were
there was no
seized.
interim order then. There was no interim order, my
So,
lord. The interim order
they
passed
have
in the suit is
instituted the
prior in
suit
time.
when the matter was reserved for orders at the last end. Then they institute the suit in
But
order
this
to
very
divert the
argument is
entire issue
canvassed
to
by my
the
learned
suit.
friend in that. Sorry, let him finish. On VC, perhaps we
Therefore,
can't
Lord,
see each other.
now the interim order court has issued, heard our side, and it could hear their side and then pass final orders on the interim application.
But may I just pass on the,
What is the settlement agreement?
but I'll just point out. May I just pass on? This is the order passed in the civil court.
No, they are relying on settlement agreement.
But yes, we have questioned those very documents in a suit. But what happens is they institute a Section 9 proceeding, as my learned friend said.
What is that settlement agreement?
But what had happened was this: I am the prior user, my lord. The appellants before your lordships are the prior user meeting from 1985. Their best 1985.
5 or 9?
I'm sorry, my lord.
89 or 85?
1985. Their best case is that they are prior user from 93, which of course I question, that's a different matter. They start using this mark because they are related to me. We are all relatives. He is my brother-in-law. The promoter of, my lord, the respondent group is the brother-in-law of the appellant group. Now, my lord, what happens is that there is an understanding between us that I will procure orders from customers and, my lord, through tenders, and they will manufacture for us. This goes on for a long time. Sometime in 2000, there is some resolution of disputes that was sought to be made. But in doing so, the documents that are drawn up according to us are not got up. Anyway, I don't want to get into the merits of it because really what your lordships are doing is to relegate us. Now, therefore, what they do is in 2024, sometime in July, they file a Section 9 petition. That petition is pending. No interim order is granted. In December 2024, I file a suit questioning that assignment agreement, by way of which they claim the trademark.
Right, 24.
I'm sorry, I'll give you a lot of the exact date. It's in I'm sorry, I stand corrected. May 24. In May 24, they filed the Section 9 petition, no interim order granted. I file a suit questioning the assignment agreement, which is the no, their case. That is not the Section 9 petition. Yes, no. The main petition is not decided. The interim, yes, interim application in that is decided. In December 24, I file a suit questioning the very assignment agreement, which is the basis of their trademark, and there is an interim order granted in my favor. So the first interim order granted in the interstate disputes between us is in my favor. I try to bring this to the attention of the learned commercial judge in this Section 9 petition when it is reserved for orders on 8th January. That is not taken on record and this order is passed. Now, this order is a fairly detailed order and really nothing much remains between this and the main matter. Therefore, my lord, my request to your lordship. And of course, since my esteemed friend Mr. Reddy is now appearing, my only suggestion and submission would also be that the parties sit across and thrash it out, because ultimately it's only the family that is suffering one way or another. By me bad-mouthing them bad-mouthing me, nobody is achieving anything. Now that, my lord, we have my learned friend appearing and we have the benefit of somebody whose good counsel they will listen to. That was the other suggestion I had, my lord, for your lordship's kind consideration. Because in the other matters also that your lordships have seen,
where we are being referred to mediation, my lord, the parties are able to, initially first day they will vent all the spleen. The second or third session, they sit across and my lord, talk in a little more calm and methodical manner. Anyway, my lord, that is always open. Parties can always explore that. And now that we have Mr. Reddy appearing, I thought we could take the benefit of his good offices, whatever, sir.
Right. What exactly has transpired here is the settlement deed records the trademark in my favor, Lord, and records the fact that I am entitled to it. Now they want to dislodge this by filing a suit, claiming that it has been entered into without any valid
Correct.
basis. But Lord, the issue is that we moved for interim injunction because they're violating the trademark when the settlement deed was in existence. At that point of time in May, court heard us for about 6 months, till December 2024. On the last day of December 2024, when the court reserved the case for orders, interim orders, afternoon they file a suit. And they try to divert the entire issue into a different forum. And there is an arbitration clause that governs, there is a CMP notice that is issued. So therefore, Lord, after the interim orders are granted, in between the reservation and the grant of interim orders, they produce the civil court orders. So they are virtually, this is an abuse of process by the appellant herein.
I don't know how my learned friend says
And
this.
how they are playing around with two forums after arguing here to the fullest extent. Now,
But I'm a bit
the issue now is that it has to be finally decided. We have addressed our arguments before the CMP court, before the interim orders court. Therefore, finally, if they argue, and then the court could take
But
a
we have
decision.
not yet been heard there. We will argue. There's no difficulty about it. But what my learned friend says
Yes,
is may not be entirely
learned
correct.
friend could.
What my learned friend says may not be entirely correct.
The order is
But-
made. Yes, anything?
Yes, so that's it. That's it.
Please, grateful.
The order is January 2025, passed by 88, that is L, Roman, L triple X, V triple I, 88. Additional city civil instructions of Bengaluru, in commercial application number, commercial arbitration application number.
Please.
168 of 2024.
160 of 25, 2024, which is under challenge in this commercial arbitration petition. It is commercial arbitration petition.
Yes, Your Lord.
Arbitration petition. Full stop. The order reads as under. Quote the order, page 73 of 84, 73 extending to 74. We take a look at the respondents as the applicants in the application number 69 of the arbitration and conciliation 1996. Sought interim measure seeking relief in the nature of injunction against the appellant herein to prevent the appellant from using trademark of the applicants. Taurus, capital TAURUS. Which is a trademark brand name for the purpose of selling, under which trademark the applicant claim that under the said trademark they are used to sell and deal in the electrical items.
Please.
It is the case of the appellant hearing that they are the prior of state trademark since 1985. It is the further case that the present petitioners have instituted original civil suit number 1771 of 24, in which the injunction is granted to civil court that they have
on 26/12/2020.
I ordered it at 26/12/2024. Where I got. It appears that the parties are family members engaged in the business of selling and supplying the electrical equipment. The case of the respondents hearing for their application of Section 9 was based on the settlement agreement and the assignment deed, which documents from according to the appellant hearing were court executed by force from them. It is the case that these documents are subject matter of the aforementioned civil suit. On the other hand, learned senior submitted that the injunction granted in the civil suit was subsequent to the civil suit was filed subsequent to the filing of Section 9 application and during dependency thereof. He sought to defend impugn order whereby the appellants are injuncted from using the same full stop. While the above is the broad outline of the controversy, and learned counsel for the respondents, counsel for the parties raised their submissions, the court finds it not necessary to go into the merits of the arguments at this stage for the simple reason that the order impugned is passed below IA number 2, 4, filed by the applicants. The IA is allowed by granting the aforesaid injunction, whereas the current proceedings of Section 9 of the Arbitration Act are kept pending and are not disposed of.
Please.
Full stop. The practice of keeping the proceedings under Section 9 of the Arbitration and Conciliation Act 1990 pending and passing interim orders in such proceedings. The courts not advised by the court. Full stop. The practice of keeping the main proceedings under Section 9 pending and passing interim orders therein deserves to be deprecated inasmuch as it leads to not only delay in the disposal of the application under Section 9, but also leads to results in the multiplicity of the proceedings. When the main proceedings are pending and the present is an interim order, the court is not inclined to consider the challenge thereto at this stage. Full stop. It was submitted by learned counsel, civil counsel to parties. Court below has already heard Section 9 application. But the final order was not passed, rather interim order came to be passed. It was submitted by learned senior to the petitioner that this case, that the injunction is granted in the suit, was liable to be considered, but the court below has not applied, it's fine to be said as well. As against this, in this regard, if the stand of the respondent hearing that section 9 application from 5 as back as in May 2004, 2024, whereas the suit was instituted in December 24. Full stop. Be that as it may. Correct. When the current proceedings under section 9 are still to be disposed of, court considers appropriate to permit both the sides to raise their contentions.
Please.
Before the court will. Full stop. Parties are at liberty to canvass all the contentions available in law
So,
to them. Court below shall, the court below shall permit the parties to raise their arguments, decide the proceedings afresh in accordance with law.
so,
Goes without saying that since this order is interim in nature, the findings in this order shall remain tentative.
Lord.
It is clarified. The aforesaid exercise of deciding afresh the commercial application, deciding the proceeding in section application in section 9 of the Arbitration Act 1990 afresh shall be concluded within 3 months.
please, so,
3 months from the date of receipt of the order. Full stop. It is clarified that this court has not expressed any opinion, nor has gone into the merits of the case of the either side.
I'm so grateful.
Please.
All the contentions before the court below,
Are left open.
both the sides are open at large to be considered on their
I'm grateful.
merits. Full stop. It doesn't.
Not, could it be 2 months, blood? Because we have already completed our arguments.
We have intervening vacations that in fact, I was going to.
Okay. We'll say 10 weeks.
I leave it alone.
10 weeks. 10 weeks.
10 weeks.
Please. Oblige. Oblige.
Seal number 2. Abhishek.
It's a non-compliance of the direction issued by the
Okay,
single
sir.
judge order, my lords. Order is at page number 15.
This pension
Please,
returnable on 10th of June.
oblige.
Seal number 3.
Make resolution. Impugned order is at page 16, operative portion. There is a delay of 118
On
days.
1 year.
Pardon, minutes. We have explained the delay, minutes. Moreover, 118 days delay is there.
There is
Your
no
lordship,
delay. Either it is maintainable or not maintainable. What is your?
it's maintainable, minutes, because for the simple reason, minutes, the lordship may also kindly see here 15, page number 15. Para 4 may kindly be seen for a minute. They admitted, and then we said this, and then we approached them post this also.
12th of June.
Emergent notice may kindly be given, minutes. We are in.
Pardon?
Emergent notice may kindly be ordered, minutes.
Why emergent?
Pardon, minutes.
Why emergent?
We will also take notice to the other, the respondents here.
So it is already issued, emergent note.
Along with that, minutes, we will also serve.
12th June, yes.
Grateful, minutes.
Number 4.
I'm opening for complaint, my lord. The single judge directed
13th June, notice.
Seal number 5, Mr. T. Govindraj.
I appear for appellant, my lord. In this case, my lord, there were 2 previous orders in writ petition number 8,003 by 2020 and another writ petition to 840
There is no
but 20
direction here.
direction. Kindly issue the
issue notice to the court.
No, no.
We were ready to remit
is
the
the-
amount.
Where is the
1,000.
direction, Mr. Counsel, where is the direction which can be complied with?
And,
When the
and,
additional area was occupied and was claimed by the petitioner, separate amount was required to be paid by the petitioner.
yeah, we were ready to pay.
Very much time.
Two times we were ready to pay the amount, my lord. On 21/11 to 2024.
What is this, madam?
That's, the order has been set aside by the Assistant Commissioner. And the matter is remitted back to the Assistant Commissioner, my lords. The date also has been given.
So what is the contempt, Mr. Counsel?
There is, as such, there's no.
Contempt
No
is,
time.
as per the orders by this honorable court, we were ready to pay the amount in 866 bar writ appeal, my lord, writ appeal 866. And at that time, he was not ready to get the amount. He says that we have filed the RP number 476 bar 2024, that is there. And again, that was disposed of. Writ appeal was also disposed of by this honorable court. And we were also ready to pay the amount on 10/1, my lord, 2025. But in spite of it, he has stated that they are going to prefer the appeal again against the orders of the single judge. So when the matter is final, we are ready to pay the amount at the rate of 1,580 per square feet. He is bound to
Accepting the
abide by the obedience, my lord.
That's the,
page 35.
page 14 minutes.
Page 35 order. I read the writ petition in writ petition 40/25 is allowed passing the communication dated 28/11/2023, and the writ petition in the 8,003/2020 is disposed of, permitting the petitioner 3 months time from today to pay the price for the additional extent in terms of the communication dated 28/11/2023, calling upon the respondents not to take any coercive measures in this regard. So when we are ready to pay the amount, he says we have already filed the revision petition RP 476 for 2020.
Notice returnable on 16th of June.
Much obliged.
Number 6, Akash Kumar Road.
Notice written on 17th June.
Number 7, Mr. Basuraj Patel, GK.
Notice written on 17th June.
Number 8,
Appealing for, right, I have filed, inserted the copies since the file was under process. I have inserted the translated copies since the file was under transmission, my lord. I have filed two paper books separately in the office itself, my lord, by inserting my lord, this is a public interest litigation to preserve the land for Gomal, grazing of Gomal land, my lord. Since we are submitting representation since from the year 2005, my lord, 2013. Every year, my lord, we are almost submitted representation to preserve the Gomal land for the grazing of the cattle, my lord. Despite submitting the documents, my lord, so far they have not considered, my lord. Therefore, we are constrained to approach the same court.
So you go on to going to Assistant Commissioner and MLA, go everywhere.
My lord,
Come to the court.
the same court, my lord, in fact, my lord, directed the state government and circulars have also been issued to preserve the land, my lord. And despite we are approaching the authorities, we have approached.
So made your representatives to MLA also. You go there.
We have approached all the authorities, including the state government.
Go there to the MLA.
Ma'am,
They are the right forum to address these grievances, not the court. Third learned advocate, Mr. So-and-so for the petitioner. Also, the present petition is filed, styling it as a public interest petition. The petitioner's case is that the
Specific direction issued by the Assam Court in the writ petition itself, my lord. Annexure C.
petitioner's case is that the land bearing survey number 41 at measuring 16 acres situated at Attigere village, Kasba Hobli, Magundi, MAGUNDHI, Magundi Gram Panchayat, Bangalore Taluka, Kolar district, as well as survey number 2 at measuring 15 acres and 19 gutas. Further, survey number 9, public P1 at measuring 6 acres and 4 gutas at Hirenna Laguthalla Halli, Kasba Hobli, Bangalore Taluka of the same panchayat. Is a Gomal land. Gomal land.
No, Gomal land.
Gomal land and required to be preserved for the purpose of grazing of the cattle. Full stop. Petitioners are referred to decision of this court in writ petition number 14048 of 2005 and the circular issued by state government dated 24/12/2005 to further and substantiate their case. It is the say of the petitioner that the certificate issued by the veterinary hospital with regard to the number of cows, buffaloes, etc., as well as the photographs produced show that they are Gomal land. Full stop. From the very prayer of the petitioners, it is evident that the petitioner have already made representation, several representations in relation to their grievance. Full stop. On 21/1/13, representation is made to the Assistant Commissioner Kolar Taluka, on 24/2/18 and on 2/2/18. The representation is made to the Member of Legislative Assembly, Bangarpet Taluka, Bangarpet, and also similar representation is made to the Deputy Commissioner Kolar on 22/5/2020. Since the representations are pending, in that view, and in view that the subject matter is liable to be better considered at the level of the authorities, since the authorities have yet not applied their mind to the case of the petitioner, the present petition is disposed of by directing the authorities where the directing the Deputy Commissioner.
My lord, the representation is dated 2013.
To look into the grievance of the petitioner. For this purpose, the petitioner is permitted to make a press representation within 15 days, which shall be considered in accordance with law and on merits within 6 weeks thereafter. And the decision shall be communicated to the petitioner. This court has not gone into the merits of the aspects of the case of the petitioner. It is entirely for the authority to consider the case and the grievance of the petitioner and the grounds which may be raised by the petitioner in the representation. The present public interest petition is not entertained, subject to above limited observations.
Number 9. Mr. Vishwanath, the PA.
My lords, final electoral roll 2025 was released on the month of January 2025, my lord. In the month of January 2025, final electoral roll was released, my lord, by the respondent number 1.
You ought to raise your objections. at the time of draft lot of voters list.
My lord.
The entire machinery is functioning for preparation of the electoral roll.
Yes, my
The
lord.
State Election Commission.
Yes, my lord. Last week I could hear the news, but at the same time, the door-to-door physical verification of the voter list.
Go to the Election Commission.
Yes, my lord, we have been, and they have stated that still it is not made mandatory. And till that that is not possible for us. And my lord, we in the page.
So this revision of role is a continuous process. Whenever it is undertaken afresh, you can raise your objection.
My lords, in the
It is not a static thing.
My lord, in the
Periodically, the roles are revised by the State Election Commission as well as the Central Election
Yes,
Commission,
my lord.
based on the role of the Lok Sabha Assembly constituency.
Yes, my lord. But when it comes to the deletion of dead persons, and also if at all my name is
So the
appearing
Petitioner Council.
in some other wards, my lord, the only. My lords, the voters are given voting rights and ID cards in that wards totally unknown to them, my lord. The voters are shuffled intentionally with other wards to make sure that they don't vote for the problems which they are facing in their own wards, but only for the sin money they are receiving at the time of elections, my lord. This is happening, and that cannot be curtailed without prompt, authentic, door-to-door physical verification, my lord. And we could escalate everything, and we pointed out the examples also, my lord.
The petitioner herein claims to be a registered association in the name of the Ideal Democratic Empowerment Association, to further claim that it is engaged in spreading the political awareness.
My lord, in the page number, I would like to bring to the kind attention,
details
page
of
number
the-
35, my lord. We could,
Details of-
we at the glance itself, we even pinpointed the examples wherein dead persons are arriving.
The details of
intentionally.
the petitioner given in the pleadings indicate that the first petitioner is an advocate by profession. Paragraph. Yes.
My lord, in the page number 35, my lord, we even pinpointed the examples wherein dead persons are still arriving in the voter list, and even wherein the people are shuffled intentionally with other words, my lord, simply because they should not vote for the problems they are facing in their own words, just for the sake of money, sin money they are receiving at the time of elections. We have been escalating every time. And even the letter communications we could see in the annexes we have provided, madam. All the petition complaints also. They have not been, they are saying that, yes, there is a need for mandatory linking of Aadhaar and all. That is one way of curtailing the menace to the off of it. But physical verification, door-to-door verification with transparency, wherein the active, the public is also involved, and the NGOs are involved, wherein they could see transparently what is going on. That is also very much required, ma'am.
Respondents here in paragraph are the Chief Electoral Officer and the Karnataka State Election Commission. The prayers are sought against the respondents for conducting authentic and transparent door-to-door verification of the voter ID cards and re-evaluation of the voters list by deleting the duplicate and fake voters. The petitioner wants the respondents to draft methodologies which may be adopted for ensuring the authentic, transparent, and foolproof. What is that? You go to page 16. Foolproof. Prayer 2, line 4.
Yes, well. foolproof deletion of duplicate voter ID
So,
card,
FOOL foolproof.
my lords.
FOOL foolproof.
Sorry.
You don't know anything.
Yes, my lord, it is not foolproof for now because we have already pinpointed the
What kind of drafting this is?
my lords.
We are presenting a drafting to the High Court. And you are saying that foolproof, FOOL foolproof. What is this?
Transparent.
Have you kept any dictionary in your office or not? English dictionary is there in your office?
My apologies for the
Foolproof, FOOL, foolproof deletion of the duplicate voters and the fake voters identity card. Paragraph. Learned advocate Mr. So and so highlighted the case put forward by the petitioner from paragraph 4 of the petition stating that the voting rights are given in the list of voters, which is published on which date? On the list of voters published by the respondents who are totally unknown persons, and that their identity is not supported by any proof, including the Aadhaar card. It is alleged that many double voters having multiple voter identity are included in the list. It is alleged that these voters vote for money in the election. It is contended, paragraph, that it is cannot be expected that every Indian voter would volunteer to link their Aadhaar card with voters' identity cards. It is stated that only educated people and citizens can link their Aadhaar card to voter ID card. Therefore, the process of preparation of list of voters is not foolproof and has many loopholes. Full stop. It is an admitted position, paragraph, that the list of voters have been revised by the respondent authorities and the final electoral roll was published on 6/1/2025. Full stop. The petitioner states that it did not show any improvement from the draft electoral roll and that the survey was not undertaken to eliminate the bogus voters. Full stop. At the outset, it is to be noticed, paragraph, that the petitioner had already made a representation, an appeal, dated 1/6/2024, in relation to the grievance sought to be agitated in this petition. Full stop. In the said appeal, the election authorities, respondents herein, were urged to look into the to submit that there were loopholes and the electoral reforms in the municipal elections were needed, especially in relation to the proper preparation of the list of voters. Full stop. This appeal was considered by the State Election Commission, Karnataka, and endorsement dated 14/6/24 was issued, which saves the same figures on the record of the petition. Full stop. It is clearly stated that the appeal of the petitioner was examined in relation to the subject matter, and it is stated that the election laws into amendment or bill 2021 requires that the election voter ID cards cannot be refused just because of non-provision of the Aadhaar card, and that action has been taken to that effect. It is stated that as regards the other aspects, the State Election Commission adopts and uses the data available from the Central Election Commission to prepare the list of voters. Full stop. After this decision, of the State Election Commission communicated to the petitioner, the petitioner has sought to invoke the jurisdiction of this court, styling this petition as in public interest. Full stop. The process of preparation of electoral roll in any election paragraph is a continuous process. Full stop. The list of voters for any election, whether it be a parliamentary election, legislative, parliamentary elections, elections to the legislative bodies or elections to the local bodies of the local self-government are prepared in accordance with the statutory provisions contained in the relevant statutes. Full stop. The mechanism is provided for preparation of electoral rolls in each of such statutes, which are followed by the election conducting authorities. Full stop. The provision will be invariably found in such mechanism whereby, the objection could be lodged to the draft list of voters for correction. Full stop. The precise mechanism is acted upon and it results into preparation of the final list of voters. Full stop. The petitioner has remedy to ventilate his grievance by pointing out the loopholes, if any, in the electoral rolls when the revision of electoral rolls takes place in future. As stated above, it is a continuous process undertaken by the Election Commission. Full stop. The prayers in this petition cannot be granted. The public interest petition is not well conceived. It is dismissed. The petition is dismissed.
The 10 is urgent. Number 11, Srinivas Keynes, the green bench matter.
For the petition. This is the petition seeking writ of mandamus, my lord, to consider my representation. My lord, all the formalities have been completed pursuant to grant, my lord. The state government has granted the lease by issuing a notification at annexure G, my lord, page 41, English version at page 44. And all the form, everything is completed, only except executing the lease deed, my lord. That's why I'm seeking, my lord, to consider our representation at annexure M. Page 66, my lord.
So it is in process. Your application is in process.
Yes, my lord, everything is completed, my lord.
No, this the director has intimated the first respondent to get the joint spot inspection.
Well, it has done, my lord. Kindly, my lord.
Then they will take a decision.
It is done.
My lord, it's
Annexure
coming up
B
for
has
the-
been produced.
Annexure
They have
B.
inspected, my lord, the report has been submitted by the Tahsildar along with the AC, my lord. Annexure B
What is the report?
at page 26, my lord.
Hmm.
They have inspected the land, my lord, and they have given the report, my lord. This is the report of the Tahsildar.
Hmm.
They says,
So it is in favor,
yes, my lord.
in your favor.
My lord, it's coming up for the first time. My lord may have this next week, my lord. I'll just intimate, next week.
Disposed of by,
My lord, I'll just intimate it's coming up for the first time, my lord.
You
And then my lord may pass any order. It's just.
no,
to
no, we are not passing any order. To consider the pending application. That's
Yes.
all, in accordance with,
Very well,
nothing, no.
in accordance with law.
Yes.
Next, full stop. Heard honored advocate, senior advocate, so and so, for the petitioner and learned additional government representative in Electoral Akbar, who appeared to assist the court upon service of the copy of the petition in advance. Full stop. By invoking jurisdiction of this court under Article 226 of the Constitution. The petitioner is paid for a direction against the respondent authorities to consider his representation dated 7/9/2021. It is further paid, it is next paid to direct the respondent 3 and 4 authorities, who are the Director of Mines and Geology, Bengaluru, and the Deputy Director, Prospect, to execute the mining lease by granting the core lease to the petitioner pursuant to notification dated 31/1/17 issued by the state government. The case of the petitioner, stated in nutshell, is that an application came to be filed by the petitioner for grant of core lease for building stone, which is a minor mineral, in the land survey number 418, at measuring to the extent of 8 acres, in Chikka Keri Jinahalli, Chikka Keri Jinahalli village, Sandur Taluka, Bellary district. The chronology of events highlighted by the petitioner shows the journey of the application, which was filed by the petitioner on 27. Journey of the application and the consideration thereof stage by stage. Full stop. It appears that the paragraph, it appears that the petitioner is relying on provisions of Rule 8/2 of the which rules? Karnataka minor mineral rules
Minor.
and notification dated 30/12/24 issued by the state government, which contemplates, in light of Rule 8/2, for consideration of the saved applications within 36 months. Full stop. It appears that on 22/8/24, the senior geologist, Department of Mines and Geology, Bellary, has sent a letter to the director seeking approval for execution of lease deed under the aforesaid, under Rule 8(b) of the Karnataka Minor Concession Rules 2023. Full stop. It is stated by the petitioner that on 9/10/24, the third respondent director has intimated respondent 4, the deputy director, to get joint spot inspection report from Deputy Commissioner Bellary. Full stop. Learned advocate for the petitioner paragraph points out from the record that such inspection. Where is that?
Page 20,
Page
27, my lord.
has already been taken place and the report is submitted, which figures on record into brigade. Report dated 10/3/15 is submitted, which is produced on record at Annexure B, with translated copy. Full stop. From the report from the said report, it was claimed by the petitioner that it stand in favor of the petitioner for its contents, and that there is no impediment for granting the co-release and executing the lease deed. Full stop. While the aforesaid facts stand in the background, comma, it is to be considered that the representation of the petition dated 7/9/21 is pending, and the prayer is made in this petition to direct the respondents to consider the same. Full stop. Until the representation is considered and appropriate decision in accordance with law is taken by the authorities regarding the claim of the petitioner to be granted the lease and for getting the deed executed, comma, the second part of the prayer cannot be granted. Full stop. In the aforesaid view, the only direction which court can grant in this petition is to direct the respondents to act through their competent authority to consider and decide the representation dated 7/9/21 of the petitioner by taking into account all relevant aspects, both factual and legal, and take a decision in accordance with law and on the merits. Full stop. Such decisions shall be taken within 8 weeks from the date of receipt of the present order. It is clarified, paragraph, that this court has not expressed any opinion on the merits of the case of the petitioner. It is entirely for the competent authority to look into the merits and to consider whether the lease is liable to be granted to the petitioner or not. Full stop. This petition is accordingly disposed of.
Obliged.
This petition is disposed of in terms of the above observations. Yes. Yes.
Yes, so still number 12.
Here for the petition. This petition is an identical petition lot to the batch of matters wherein your lordship was pleased to grant interim order. In fact, this was the first petition challenging the drone survey conducted in the year 2018-19.
7.5 lakhs.
7.5 lakh, Lord, based on the circular.
Doesn't appear to be.
My lord, I need some time to look into this.
This doesn't appear to be same petition.
It's not that, my lord.
May I take your lordship to annexure X, page number 213. Based on this circular only, your lordship was pleased to grant stay. And this circular was issued on the basis of the very same petitioner's petition.
213.
213, it is in Kannada, Lord. 216 is the translation. This is the proceeding of the state government. May I read? Subject. Regarding the provisions of additional grant of determination of quantity of mineral extracted from the active quarry leases area through drone survey in the state. In the above preamble, on the basis of the complaint submitted by ex-MLA so-and-so, constituents submitted the legislative petition committee stating illegal building quarrying activities in various villages of Malur Talukola district has been going on by illegally creating documents. Survey of the quarry lease area granted in the said villages has been conducted. The Honorable High Court in the writ petition number 29870 of 2019 dated 3/12/2019 and writ petition number 13252 of 2019 dated 28/11/2019. Lord, this pertains to the very petitioner. Yes, WP 13252 of 2019. And one more writ petition. The action of assessment of quantity of minor mineral extracted from the quarry lease area using drones instrument has been upheld. However, it is necessary to issue notice to provide an opportunity to submit reply and ensure that the notice issued along with the drone survey report. Therefore, notices already issued demanding penalty payment have been cancelled. The last may kindly see. The notices issued in respect of the very same petitioner has been cancelled. And subsequent thereto, Lord, one more circular at annexure Y, page number 221, referring the very same writ petition has been issued. reiterating, my lord, 221. 221 last pair. In the last but one pair, my lord, in the writ petition so and so, in the in which, my lord, WP number 13252 of 2019 measures SR Stone Crushers, that is the petitioner herein. Honorable High Court upheld the use of drone-based survey.
I mean, in drone survey, you can measure the area and
The longitude, latitude, they all, my lord, on the basis of, my lord, those, my lord, they calculate how much of illegal and legal quarrying is going on.
you can measure it.
Yes, yes.
But area you can measure or pinpoint.
But not even the leased area also. In
That's
the
right, but then the quantity how can?
No, my lord,
quantity there.
may clarify, my lord.
Quantity ಕೂಡ ಮಾಡ್ತಾರೆ.
So it is a recognized method?
Yes, yes.
No, that came into force in the year 2020 in the rule book, my lord. This was done in the year 2018-19, and this came into the rule book in the year 2020. And in the year 2023, there was an amendment to conduct drone survey prospectively, not to the retrospective effect. And so far as this petitioner is concerned, the government contemplated to conduct one more drone survey, providing an opportunity to all the leaseholders. And after conduction of drone survey, a report shall be submitted, given to the petitioner. After seeking their objection, the audit has to be finalized, was the decision taken by the government. Lord, in pursuance of this circular at Annexure X, the competent authority conducted proceeding. In my case, Lord, conducted proceedings and allowed us to conduct quarry operation. And undertaking was taken by the leaseholder to the effect that in the prospective drone survey, if there is any illegality or is found, to that effect, we are ready. We have to file an affidavit to the effect that we will fulfill the amount demanded. Based on that, Lord, quarry was reopened and quarry was running. When the quarry is in subsistence, the incumbent competent authority, who has no authority to review the order passed by his predecessor, he issues a notice at Annexure B, stalling the issuance of mineral dispatch permits. There is a clear judgment, there are several judgments of this Honorable Court to the effect that when the quarry lease is in subsistence, the mineral dispatch permit cannot be denied. I am placing a reliance on the judgment of...
This writ petition 13252 of 19 is pending?
No, that was disposed of.
But Lord, it's there at paragraph.
Lord, I have produced that
89.
in page number 189.
My lord, page 207 may be seen. The orders passed by my lord, the coordinate bench of this full court. This is not complied with. Revision is filed.
This is the order, Lord. Subsequent thereto, the government passed the proceedings at Annexure X.
Government passed?
This proceedings, Annexure X, which I have drawn the attention of, 216, Lord, page number 216, referring this very judgment. And your lordship was pleased to, Lord, grant stay in all those batch matters based on this circular.
No, my lord. I need some
Was
time
it
to
in-
verify.
Those matter did not arise from the revision process. They were the
Hello?
direct petition.
Plus, my lord.
The petition in which the orders are passed regarding 7.5 lakhs
Yes.
were a direct petition,
Yes, direct petitions.
not from the revision.
No, no, no.
Ah.
No, no, that is from the revision. The revision was passed, the order was passed by the secretary. No, no,
It's by the, I'm sorry, the secretary, my lord,
No,
the government.
that is the
Yes,
same
yes.
thing. Here also the same, very same.
No, no, this is passed.
pattern, sir.
No, my lord, but this, my lord, there is more than 6 crores are not due.
There
And
also, my
with,
lord, 32 crores.
My lord, with due respect to my learned friend, my lord, he may be having more information with regard to this. My lord may grant me some time to verify that and make a submission. Anyway,
Lord,
the petition is
make a
pending.
submission.
My lord may see the demand notice is of the year 2024. Order is passed in February 2025. We haven't precipitated. Nothing has happened.
No,
And
my lord.
it's pending before my lords.
No, they have issued one more notice recently on 24th March 2025. Not demanding this 50% on the non-existence notice. This is not inexistent at all.
My lord, that.
And one more submission is, Lord, your lordship may kindly peruse these two judgment of this honorable court.
My lord, may I see the order that is passed in page 207, my lord. There are several directions. And because of non-compliance of that, my lord, maybe this notice dated 24/3/2025 is issued. And now that it is pending before my lord.
No, no, that is on fact, it is not correct. It is incorrect.
Very good, if it is not correct.
May I impress upon your lordship, Lord, by producing this judgment. My first submission is that, Lord, this notice is not in existence. In pursuance of this proceedings of the government of Karnataka, competent authority has passed an order keeping this notice in abeyance and allowed us to conduct quarry operation. That order is produced, Lord, at Annexure AA, page number 244. That cannot be denied by the other side, Lord. The very competent authority has allowed us to conduct the operation in pursuance of the order passed by this honorable court, as well as the order of the state government. And a circular has been issued to that effect. That is also referred in the order of the competent authority. Now coming to the second aspect of the matter, Lord, denial of.
This appears to be different.
It's different, my lord. It is not that. My lord, and my lord, the orders of my lords have not been obeyed. My lord, against that 50% that was to be deposited, my lord, they file a revision. That revision has been dismissed, which is produced as Annexure A. To escape that payment, my lord, all kinds of extraneous, my lord, submissions are made.
I'm sorry, my lord, it is an incorrect submission. May
My lord,
I take your lordship in a chronological order? May I take your lordship in a chronological order? After passing of a judgment by this honorable court, your lordship may kindly see.
207 order is very clear.
I have produced that order before the court.
Yes, nobody
I have
denied
not
it.
suppressed anything. Lord, this is one aspect of the matter, Lord. So far as
What is the amount demanded?
6 crores 83 lakhs.
Where is that?
My lord, that is, they have produced the demand notice. It is dated
Lord, in
21/9.
in page number 194, in the order itself, it is mentioned. The very notice has been challenged before this honorable court. In page number 194. Para 4 last.
Internal page 6 of the order, my lord.
So in this,
Yes, my lord.
what was the amount directed to deposited at the interim stage? 50%?
50% has
To be and 50%, and that 50% has not been deposited. They file a revision.
No, page 207.
Yes, my lord.
That case, the bench set aside the demand notice and subject to petitioner said that subject to petitioner complying with the condition incorporated in the interim order by depositing the requisite amount. What was that amount? So it is at least 50%, at least 50%. 50, it is 50%. So this also order you are relying on requires you to deposit 50%.
No. May I make a submission? In pursuance of this order,
Even that is not paid, as I submitted to my lord, then a revision is filed.
No.
My lord may grant me some time.
no,
to
it
think
is not correct.
my lord, and
No
make the
revision is
revision.
filed.
Annexure
We-
A is there, my lord.
We have sought for modification of this order,
Which order?
this writ petition order, interim order, citing the difficulty in the COVID time. Thereafter, Lord,
That has been withdrawn.
thereafter,
You address the court.
please. Thereafter, this circular, Lord, this government order at page number 314, please.
314.
314. The translation is at 216.
314.
216, Lord, 216, page number 216. Last may kindly see, by referring this very judgment, that is 13252 of 2019, the government decided to withdraw the demand notice, that is in the last line of the para. Therefore, the notices already issued demanding penalty payments have been cancelled. This is the decision of the government.
Where? I don't know. So which page are you reading?
216.
222. Line is 222. The line which you read is at 222. 216.
No.
Has been cancelled.
Has been cancelled. Then may I take your, there are several circulars issued referring this.
Correct.
Thereafter, Lord, 219.
219, that
219, that is, translation is at 221.
So you let them find out what is wrong.
Yes, my lord. It's
So
a
what
simple
is your
case.
case?
My case is, Lord, this notice was kept in abeyance, contemplating a fresh drone survey. That is the order passed by the competent authority in page number 244. You'll ask me kindly. This is subsequent thereto.
During the drone survey, delay may occur. Absence of boundary pillars to prevent this co-release holders and existing co-release must establish and maintain boundary pillars. If boundary pillars are missing, they must be installed before the commencement of the drone survey.
Yes.
So
244. Relevant page is at 246.
Yeah, what happened thereafter?
Thereafter, they allowed me. They have allowed me to conduct quarry operation.
What is the result of second drone survey?
They have not conducted second drone survey. I was conducting the quarry operation. At that time, Lord, the incumbent competent authority issued a notice denying the mineral dispatch permit. I have challenged that order, that is annexure B. Your last mechanic.
My lord, seventh is too short.
My lord. Yes.
My lord, if that were to be the situation,
Yes. Yes.
My lord, there a
Yes.
submission that was made was an opportunity of hearing had not been given to them with regard to, my lord, conducting of the drone survey.
In the meanwhile, may I
My lord,
make a-
seventh is too short for me, my lord. My lord, if that were the, my lord, if that were the, if accepting the fact that the notices have been cancelled, my lord may see this annexure B that is issued. My lord, and in that at serial number 5, my lord, the concerned authority has referred to the order passed by my lords. My lord may see 5, and it is based on that only this order annexure A is passed. They could have taken a contention there that, my lord, these circulars have been passed. My lord, we are not entitled to pay. Notices, my lord, demand notices have been cancelled.
My lord, so far as annexure B is concerned,
My lord,
I have filed
this
an
is
application.
issued by an officer, my lord, with full responsibility.
Now, this is wrong because he is reviving the order passed by his predecessor. And in this case, I have filed an application for mineral dispatch permit. That can't be denied when the lease is in subsistence, is the order passed by this honorable court. Your lordship may kindly peruse that order. Yes, yes.
My lord,
No, this is a different order so far as denial of mineral dispatch permit. Your lordship may kindly see. In para 6, after consider, your last meeting, page number, internal page number 4. This is a case of denial of mineral dispatch permit. Lord. After extracting rule 42 in para 6, then para 7, Lord, in view of sub-rule 3 of rule 42 in the said rules of 1994. After the application is filed in accordance with Rule 42 on making all procedural compliances.
My lord, 7th is too short, my lord. My lord, 15. My lord, let
Lord.
me have, my lord,
Lord, in the
me
meantime,
interact with all the,
because this clearly says, MDP cannot be denied.
my lord, I don't
MDP
have
cannot be denied when the lease is in subsistence, whatever be the demand. Mineral dispatch permit cannot be. You'll ask me kindly peruse para 7 and 8.
My lord, there's heavy revenue involved, my lord.
In view of,
My lord may
Lord.
have it, my lord. No, my lord, that is incorrect.
that is the law laid down by this honorable court.
I haven't got a copy of that. My lord, and whatever my lord falls from my lord, heavy revenue, my lord.
You'll ask me.
I'll have to interact. He is aware of all these circulars.
Lord, you'll ask me kindly peruse 7 and 8. Page, para 7 and 8, please, for a moment. In view of sub-rule 3 of Rule 42 of the said rules of 1994, after the application is filed in accordance with the Rule 42 on making all the procedural compliances, the competent authority is required to make an inquiry and satisfy itself that the information furnished in the application is correct, and the applicant is entitled to mineral dispatch release order, MRDO, is required to be issued, which is valid for 30 days. Now, we will come to the decision relied upon by the learned counsel appearing for the petitioner. As far as the decision in WP number 46564 of 2019 is concerned, a writ petition in the nature of mandamus was spread for issuing MDP in accordance with Rule 42 of the said rules of 1994. In this case, a notice was served to the petitioner calling upon him to show cause as to why the lease should not be cancelled. The division bench found that the mining lease was valid and subsisting, and therefore directed to issue MDP. In WP number so and so, the petitioner was granted 2 mining leases which were valid and subsisting. Notices was issued calling upon the petitioner to show cause as to why the mining lease should not be cancelled.
Honorable court, my lord. My lord, we haven't withdrawn. If we had withdrawn, my lord, we wouldn't have issued an extra B, and that too before my
That is, record is there on record. Lord,
No.
they cannot deny it.
No, my lord, this request.
What?
It's not withdrawn.
Lord, in my case only it is withdrawn. Referring my own case. (216). Yes, 13252 of 2019, referred in para 2. That's my petition. Yes. And in subsequent notices also, Lord.
My lord, that is his English translation, my lord. I wouldn't know. My lord may grant me some time, my lord. I don't have the
This is
assistance of the learned
this is a
advocate
kind
general
of
because
submission.
my
This
lord,
is not
he's
the first time I am producing this.
No, he's indisposed, my lord. Yes. My lord may have this on 15th, my lord. I'd like to bring this to the notice of the learned advocate general. I don't have his assistance, my lord, because he's indisposed.
Lord,
This is the contention, that is the complaint.
Lord, keeping this issue apart,
My lord may have
keeping
on
this
15th,
issue
my
apart,
lord.
in this judgment, Lord, even if there is a demand notice, when the lease is in subsistence, so long, it says, Lord, so long as the mining lease is valid and subsisting, the respondent cannot refuse to issue MDP in respect of minerals lawfully excavated by the petitioner from the lease area.
My lord, page 189. At page 207, my lord, all the, my lord, five directions that have been given may be seen, my lord. 5, 4, 5. They are all interlinked. Page 207. Yes,
May I make?
everything, my
Lord,
lord, there's
after this,
confusion with all this, producing circulars. Within a period of 8 weeks from today. And the date is 28/11/2019. It is made clear that if the compliance of the condition imposed and so and
it
so
is an admitted fact
restored.
that non-compliance of that order, it revives the notice. There's no doubt about it. I'm admitting that. But in pursuance, non-compliance of this order revives the notice. There is no dispute about that. I am admitting that fact. However, the government consciously, in the proceeding dated 10/9/2020, withdrawn this notice. And your lordship may kindly, this is the order, 213. That is 216. Yes.
My lord, my lords have directed within 8 weeks. And my lord may see, in case if it is not passed, my lord has also put a caveat on that. My lord, and my lord has also.
This is the order and several circular thereafter.
My lord, my lord, I don't have that. My lord,
I
that
have this.
is no connection.
So, Lord, in 32357 of 2024, your lordship was pleased to pass the interim order. And Lord, in pursuance of this circular, may I draw your lordship's kind attention to the
No. Yes.
No, Lord, may I make a submission? In page number 213, it is in vernacular law. No, Lord, I'll read the vernacular part. 213, last 4 para. ಆದರೆ ಕಲ್ಲುಗಣಿ ಗುತ್ತಿಗೆದಾರರಿಂದ ದಂಡ ವಸೂಲಿ ಮಾಡುವ ಮುನ್ನ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಅಹವಾಲು ಸಲ್ಲಿಸಲು ಸೂಕ್ತ ಅವಕಾಶ ನೀಡಲು ಮತ್ತು ಡ್ರೋನ್ ಸರ್ವೆ ವರದಿಯೊಂದಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲು ತಿಳಿಸಿ.
Yes.
That means before recovery of the amount, notice has to be served and objections has to be called for. And sadari
Yes.
ಸದರಿ ಕಲ್ಲುಗಣಿಗಾರಿಕೆ ಗುತ್ತಿಗೆದಾರರಿಂದ, that means in respect of the very same petitioners, ಇಲಾಖೆಯಿಂದ ದಂಡ ಪಾವತಿಸುವಂತೆ ಸೂಚಿಸಿ ನೀಡಿದ ನೋಟಿಸುಗಳನ್ನು ವಜಾಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. It is in respect of the very same petitioner.
My lord, that is a preamble.
Yes. ವಜಾಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಕ್ಯಾನ್ಸಲ್, ವಜಾಗೊಳಿಸಿರೋದಂದ್ರೆ ಕ್ಯಾನ್ಸಲ್. ಇಲ್ಲ, ವಜಾಗೊಳಿಸಿ, no, it is cancelled. The exact translation is produced.
Correct, that's what I'm saying. Full paragraph.
No, where it is. No, that's not.
Yes, yes.
No, that's a fact. No, before that, I have to clarify regarding this proceedings of Karnataka, cancelling the notice and further circulars issued. This is the first one. Thereafter, your lordship may kindly see. Based on this government order, a circular has been issued on 2nd December 2020 by the Department of Mines and Geology, 221, page number 221. Lord, may I read the second para. Challenging these penalties imposed through drone survey, some of quarry lease holders have filed writ petition in the High Court of Karnataka. In writ petitions also, even referring my own writ petition, the High Court upheld the use of drone survey in quarry lease areas for estimating the extracted minor minerals. However, before recovering the penalties from the quarry lease holders, after service of notice, providing appropriate opportunity to submit a reply, and it is informed to serve the notice along with the drone survey report, that is contemplated drone survey report. Therefore, the notices issued demanding penalties from the department to the said quarry lease holders have been cancelled. This is the circular issued in pursuance of this government order. Thereafter, one more circular in page number 223. Translation is at 228. May I take your last? 229, the relevant para. In 229, third para refers to the writ petition filed by the petitioner. (229). Last para. but rejected the notices issued by noticing to make the payment of fine issued by the department to the above said quarry leaseholders by intimating to be served the notice along with the report of drone survey and provide suitable opportunity for submitting their grievances in service of notice prior to do recovery of fine from such quarry leaseholder in this regard. Thereafter, my lord, page number 224 is relevant. This is the order of the competent authority. Regarding, may I take your lordship, 244. My lord, this is very relevant because that was not accepted by us. Lord, may I take your lordship to 245? That is the order of the competent authority in pursuance of these circulars. A hearing was conducted as per the direction issued by this honorable court by the competent authority. Blood.
Lord, I'm obliged.
Blood. So far as MDP is concerned, Lord, I'm relying on this judgment, Lord, which says, even if there is a demand mineral dispatch permit. Yes. Last may kindly peruse judgment. Paragraph 7 and 8.
Lord, I don't have a copy of them.
Yes, Lord.
Lord, it has to be read in the context of this case, my lord. It cannot be picked up from this.
Without knowing the facts, Lord, such
Yes,
submission
yes,
should
yes,
not
that's
be
the
made.
reason why.
Lord, here is a case. Demand notice was issued and notice for cancellation of quarry lease was issued. Your last may kindly come to para 7. Para 7. See, after extracting 42 is in respect of issuance of mineral dispatch permit. In view of sub-rule 3 of Rule 42 of the said rules of 1994, after the application is filed in accordance with Rule 42, on making all the procedural compliances, the competent authority is required to make an inquiry to satisfy itself the information furnished in the application is correct and the applicant is entitled to mineral dispatch release order, or then MDRO is required to be issued, which is valid for 30 days. Now we'll come to the decision relied upon by the Land Council appearing for the petitioner. As far as the decision in so and so is concerned, a writ in the nature of mandamus was filed in accordance with Rule 42 of the said rules of 1994. In this case, a notice was served to the petitioner calling upon him to show cause as to why the lease should not be cancelled. The division bench found that the mining lease was valid and subsisting, and they therefore directed to issue of MDP. Then, my lord, in WP number 21678 of 19, the petitioner was granted 2 mining leases which were valid and subsisting. In this case also, it is valid and subsisting. Notice was issued calling upon the petitioner to show cause as to why the mining leases should not be cancelled on various grounds stated therein. The only grievance in the petition was regard to the denial of MDPs for transporting of minor mineral excavated from the leased area in respect of one of the 2 leases. The para 7 of the said decision of the division bench has held thus. So long as the mining lease is valid and subsisting, the respondents cannot refuse to issue MDP in respect of minerals lawfully excavated by the petitioner from the leased area, only on the ground that there is a demand for penalty. Here also, only on the ground that there is a demand for penalty and that show cause notice of the cancellation has been issued. Here it has been issued. MDP in respect of minerals lawfully excavated on the basis of subsisting lease cannot be denied. Therefore, if the case is covered by Rule 42 of the said rules of 1994, notwithstanding the registration of first, here there is no first information report, etc. Therefore, it is squarely applicable to the facts and circumstances of this case, Lord. For I humbly request this honorable court to direct the respondents to issue MDP, Lord, pending the disposal. So far as issue of demand is concerned, Lord, my submission is, Lord, it is covered under these circulars. And these circulars are issued in the very same, in respect of the very same petitioner. I am filing this to the notices issues not subsequent to filing of this writ petition. Lord, there was a dispute. Interstate dispute is there. No, in respect, no, that is there in the order of this honorable court only. No, we have not disputed.
My lord, that's the reason why the revisional authority, my lord, as per annexure A, my lord has called upon the officer to page 58, my lord may see the order. The competent authorities are directed to collect the principal amount from the petitioner.
My lord, one more submission. Your last may kindly see. Page number 245. Because this is very relevant. 245, page number 245. After all this direction, Lord, page number 245. Following the, Lord, it starts from the middle of the page. Following the order of the Honorable High Court, the lessees were provided an opportunity and hearing date was set. At 245, page number 245, page 245. Lord, after all this, after direction issued by this Honorable Court to conduct an inquiry, the competent authority held an inquiry. Lord, following the order of the Honorable High Court, the lessees were provided an opportunity and a hearing date was set. During the hearing, the lessee mentioned that due to the impact of COVID-19, their financial situation had worsened. Blood.
Yes.
Blood. Further. During the hearing on 22/4/2024, Mr. Shivraj, representative from so-and-so, as per the order of the Honorable High Court in writ petition so-and-so, the circular of the central office dated 7/12/2022 issue notice for the year 17-18 based on the drone survey report are cancelled. Requested for revising the demand and issue the demand notice afresh, conducting the drone DGPS to assess the production, land and dispatch of the minerals. annexure B, denial of MDP, mineral dispatch permit. Lord, may I make one request, Lord? May. Lord, let them file their objection saying, Lord, whether they have withdrawn or not, that clinches the issue. A short, in the meanwhile.
11.
And the order of the competent. Permit.
28/11, 2019.
Yes, special. That in the year 22, there was an order passed by the competent authority permitting us to query. That is the order in 246. In this case, from 22, we have been carrying out
Obligement.
obliged.
My lord, the time period, my lord. Yes. Obliged, my lord. The
Obliged, my lord.
deposit of
However, this order is
time, my
intact.
lord.
The order permitting us to query is intact. That was not recalled.
Lord, time
That is
limit to
22nd order. That was the order passed by this competent authority in the year 22 permitting us to query. That is intact. That is how we are conducting query lease.
Obliged. Lord,
Obliged.
2 crores is to be deposited, my lord, fixing some time. Obliged.
A date may be fixed for lot. A date may be fixed for 21st. Obliged.
Lord, that's too short, my lord, since he's been given that. op- My lord, they are not same, my lord. I wouldn't, yes, I wouldn't, my lord, make incorrect submissions to my lord. He's taken up a contention that, but no, my lord,
Let them come up with a clear stand, my lord, whether they have, so throughout the state, circulars are have been issued, directing the district officers
my
to
lord,
conduct drone survey afresh.
my lord,
Please, ma'am. If there is a mistake, that has to be corrected. There is no.
my lord, there the contention taken is the quantum has not been, yes, quantified, and that they are insisting for a drone survey to be conducted so that the quantum can be quantified. Obliged.
Yes. Writ appeal matter, system number 13.
Appeared for
Yes.
appellant in this case, my lord. Lord, the learned single judge has been dismissed that rejected my writ petition on the ground of delay and laches, my lord. Annexure page 24, my lord. There are 7 of the orders of the learned single judge, my lord. Page 24, paragraph 7, my lord. Lord, initially this property was granted in the year 1960. 49, my lord. The first sale was taken place in the year 1960. Page 24, paragraph 7, my lord. The delay of more than 25 years in approaching the concerned authority is the observation made by the learned single judge. But this appellant before this court has initiated the proceedings in 2006, my lord. The appellant before this court has initiated the proceedings in 2006, page 63, my lord, after 45 years. Annexures F, my lord, sorry, page 69. The son of the grantee. Original grant is known, that my grandfather was the original grant. This appellant before this court has initiated the proceedings in 2006 and 7. From this order, that 45 years with regard to that. Annexure F, page 69. The order was passed in 2018. This writ appeal was filed in. 8/6/2020, 18. After,
Lord, Lordship's judgment is Gaurama versus Deputy Commissioner Haveri. Manjula, M. Manjula versus Deputy Commissioner. Manjula versus Deputy Commissioner.
Cell number 14, SB Mukkanappa.
I left on next week, my lord. I left on next week. Next week, my lord.
So. Number 15. Cell number 16. Shekhar.
Anybody appears for the other side? Notice returnable on 23rd June. Delay of 18 days. Then up to 17 adjourned.
For response. 17 urgent. Cell number.
My lords, one submission in serial number 17, my lords, for the past 3 occasions, they are taking adjournment without informing my lords. In fact, I have filed an application, my lords.
Both the sides mentioned. Who are you? Impleading.
No, my lords, I am the appellant in one of the connected matter, my lords.
Any urgency, dire urgency, then we can.
Please.
Number 18.
Your lordships, in the previous hearing, your lordships had directed the respondent number 2 and 3 KADB to furnish a reply as to why the entire extent of land measuring 3 acres, 7 kuntas was granted in favor of respondent number 5, your lordship. No copy has been received, your lordships.
This is the appeal coming for the first time.
No, your lordships.
My lord, there was one more appeal connected to this. There was a submission made, my lords. That's in writ appeal number 1724, my lords, of 2024.
No, your
There are two appeals, my lords. This is 1726. Common order was passed in respect to 2 writ petitions. One more appeal, my lords, is pending before this one court, writ appeal number 1724, my lords. We had prayed, my lord, that they have to take steps for the other matter also, my lords, because in the common order they are challenged it. The other writ petition.
So what do you?
Last date of hearing, my lord directed me to produce the statement of objection filed by the board, my lord, because they are not part of the records. I already filed with a memo, my lord.
Your copy is given.
No copy is not served, your lord.
After vacation.
Please.
24th of June. Within which time the copy of the additional documents shall be furnished to the petitioner.
Grateful, your lordship.
Cell number 19. Sudhindra Bhatt.
Delay of 102 days.
Yep.
Notice returnable on 24th June.
Much. 24 June.
Cell number 20. Yes, Kiran.
Hearing in this case.
Lord, petition seeking for engaged in a council, my lord, can you pass over the matter? Lord.
So it is not possible looking at the length of the board. Stand over to 26th of June.
Lord, urgency is there, my lord, that refund of amount has been ordered in this case.
Whatever.
My lord,
Can you argue?
Lord, page 13 is the order, my lord. The students, Lord, are of the year academic year 2017-18.
Yes.
My apologies, my lords.
Yes.
But the writ petition was filed more than 3 years from the date on which it was claimed that the last fees was paid. They completed their course. 3 years after completion of the course, they came back to the court saying that there was an excess fees which was paid by them. And that was a writ petition which has been entertained by the learned single judge. Lords, we raise two contentions. Firstly, the writ petition of the kind will be barred by limitation. Lords, we relied upon Mafatlal Industries case and Ram Gopal's case, which said
It was the fees collected in the year 2007.
Please, my lords.
And the petition was filed in 24.
Yes, that's lords, 1718 to 2021. 21 is the last date when the fees is said to have been paid. 24 is the date, my lords, when the writ petition is filed. We demonstrated it is palpably barred by the limitation. Because within the period of 3 years, even from the date of the last payment, they never raised an objection. Lords, the learned single judge says, Lords, though such a pleading is not there, the learned single judge, Lords, observes, Lords, at page number 33, at para 15, this is not the pleadings in the writ petition. The petitions being under the impression that the fees is not paid, they'll not be continued, so on and so forth. And it relies upon, my lords, Section 21 of the Contract Act and Section 72 of the Contract Act. Lords, this will open a Pandora's box, my lords. But otherwise also we have demonstrated that whatever fees was paid was well within the limits which was prescribed under the agreement.
My lord, contesting respondents, my lord, are respondent number 1, 2, 3, my lord, and 1, 2, 3. Respondent number 1, 2, 3 are the contesting respondents, my lord. They claim to have remitted the excess fee in this matter. And so far as the limitation is concerned, my lord, there was extension granted till February 22 by the Honorable Supreme Court because of the COVID. Though that is not considered in the impugned judgment, my lord, that's one factor. They may, on merits, my lord, they might have to contest, my lord. Respondent number 1, 2, 3.
Very well, lords. Lords, can I make this suggestion, lords? Of course, subject to what your lordships would say. Lords, whatever the learned single judge is quantified at page number 30, my lords, 30, I will deposit the entire amount before the your lordships. Your lordships may consider granting an interim order. Let them come and, because The question of limitation specifically having been raised, the learned single judge is not considered it, my lords. And interest was not sought for in the pleadings. And the learned single judge returns the findings, which is not the pleadings at all in the writ petition. Subject to what your lordships may say, my lords. I'll deposit this amount before the court. Lords, interest they have never sought for. Kindly have a look at page 49. That is a prayer. They only ask for the money, my lords. They never ask for the interest. Lords, in a writ jurisdiction, something more than what is not sought for, my lords, ought not to have been granted. It is not their case, my lords, that there was any duress with which they have paid it. That is the finding which is recorded. They never asked for the interest. Interest is aborted. We raised an issue of limitation. Limitation is not considered. Very well, my lords. As I am in your lord's absence. Please. Grateful.
I appear for the appellant in this matter, my lords. Lords, the petitioner is before your lordships in the appeal. Lords, the petitioner had sought for a mandamus, my lords, for the implementation of the provisions of RPWD Act, and also, my lords, by way of an amendment, compensation for the violation of those mandates. Lords, the petitioner, my lords, is a mother of a minor child, my lords, who relocated from the USA. The child, my lords, was diagnosed of ADHD in the USA. My lords, after relocating, my lords, she admitted the minor child to the respondent number 1 school. It had some teething issues, my lords. That is the reason what she would do is there would be a individual education plan that would have been devised by the school in the USA. She suggests the same, my lords, to the respondent number 1 school, and she says, if at all this is or this kind of an arrangement is done for the child, probably, my lords, the child could do better. My lords, the respondent number school would realize, my lords, that it is too much of a burden, too much of an effort. They would summon, my lords, the petitioner and say that it is better that you take your child away and admit him to any other school. Lords, when she would insist that in the middle of the year she could not find another educational institution and find an alternative, my lords, what they would do is they would push me to take online education. And thereafter, my lords, on flimsy grounds, nowhere before, my lords, they would have made any such allegations. On 3/2, my lords, 3/2/2024, 3/1/2024, they would summon a meeting and they would say that your child is violent, it does not exhibit social norms, and so on and so forth. And they would pass a resolution. I'm sorry, my lords? ADHD, my lords, attention deficit hyperactivity disorder. My lords, if I can explain it by way of an analogy, my lords, for ADHD, my lords, by way of a hyperactivity disorder. Hyperactivity. If I were to be a child, by way of analogy, my lords, if I may explain, I'm arguing this petition now. I see somebody playing, my lords, I run away. I will not be able to concentrate. So being a child, my lords, it is even more aggravated. It's a disorder, my lords. It's a disorder. No, I can say it is confined to the child. It can be treated, my lords, with the help of psychologists, with the help of teachers. It can be treated. The child can get better. Jai Sham Jasimha Rao, my lords.
My lords, I appear for Union of India, my lords. Respondent number 4.
I'm for respondent number 2, my.
My lords, there's a serious issue of maintainability of the writ petition, my lords. It's virtually a writ against a private school to readmit the child. Your lordships will have to examine it on that basis as well.
I'm not pressing that prayer at all, my lords. I'm not pressing that prayer. Insofar as prayer number 1 was concerned, before the learned single judge itself, my lords, I said I'm not pressing the prayer. The prayer that would only survive before your lordships is the implementation of the scheme of RPWD Act as well as the RTE Act, and a compensation for the violation of those norms as against me. Because, my lords, I'm a child of 8 years. What sort of violence, my lords, can I indulge in? My lords, if your lordships...
My lords, if the child is no
I'm
longer
admitted
studying in
elsewhere.
the school, then locus
Admitted elsewhere.
standi.
And my lords, so far as the maintainability is concerned, my lords, this is a school. It is imparting public function, my lords. I don't think, my lords, maintainability would come in the way. My lords, I'm seeking a mandamus for the implementation of the rules and the statutory mandates.
My lords, if he's no longer studying in the school, then locus standi also becomes an issue.
I'm for respondent number 2.
And more so, my lords, the respondent number 4 must be sailing with me in implementation.
My lords, I'm sorry, the court is not audible, my lords.
Couldn't have asked for it. Deeply obliged, my lords. Grateful, my lords.
Your Lordship, I'm appearing for the appellant. Your Lordship, the appellant was a petitioner before the learned single judge. She was an officer in the commercial tax department. She was suspended from the department. That suspension she had challenged before the Karnataka State Administrative Tribunal. The Administrative Tribunal does not give her a relief, so she approaches this Honorable High Court. Annexure C, page number 72, Your Lordship.
Extra set of copy, my lords. 8 days we won't approve.
Yes. Whenever there is a state who's a party or lordship in the scrutiny, they require that in it. Yes, Your Lordship. may I make one submission, Your Lordship? The petitioner, all that the petitioner has sought in the writ petition is that she has filed various representations. Just those representations have to be considered, an appropriate order has to be passed. Page 48, Your Lordship, if I may draw Your Lordship's attention to page 47, which is the very first ground which I have raised. The last two sentences on page 47, Your Lordship. The respondent number 2 being a statute. Yes, Your Lordship. Yes, yes. It is the writ petition is dismissed on the ground there is only an alternative remedy, but section 19 of the Karnataka Administrative Tribunals Act says only when an order is passed, then there is in this no order. And I've raised an issue, similarly placed officers have been given their salary. I am only discriminated. I've raised the issue of arbitrariness. That also has not been gone into with learned single judge, Your Lordship. I've taken that also as a stand. Your Lordship, page number 47. Yes, Your Lordship. My prayer, direct the respondent number 2 to consider the petitioner's representation dated so-and-so as per annexure A, A1, A2 and A3 with the direction to disperse. Your Lordship, the respondent number 2, Your Lordship. Yes. And if I may draw Your Lordship's attention to also a specific ground which I have stated, Your Lordship, that similarly placed officers have been given the salary, whereas my salary and allowances have not been dispersed fully. In this context, may I draw Your Lordship's attention to annexure C, page 71, an order of this Honorable Court, where this Honorable Court has held that this petitioner is being discriminated as compared to the other officers. And yet again, this respondent number 2 has not considered my representation.
The madam was in the final.
Yes, sir. Yes, sir. Yes. Yes. Obliged. In shorter time, Your Lordship, that means since 2023, I've been writing letters. Obliged.
But I appear for the appellant. But the appellant was an employee of my lord respondent. But please. Please.
Your Lordship, I have applying, my lord. There's a deal of 208 days, my lord. My lord, there is a connected matter, writ appeal number 268, 467, my lord, which is coming on 24/4, my lord. 24/4. Writ appeal number 469 of 2025, my lord.
My lord,
Serial number 46, my lord. 2 weeks later. Serial number 46, my lord. Okay. Today afternoon is the inconvenience of the council for the appellant.
my lord, serial number.
Please.
Yes.
My lord, serial number 106, my lords. 106. It has come under the heading of non-compliance. There's some urgency in the matter. The appellants have been taken into the custody. They were granted commutation, and the single bench has set aside the order of His Excellency, the Governor of Karnataka's order, and they have been taken into custody now. The objections may be kept open, and it may be had for hearing on the IA, my lord.
Keeping the aspect of office objections. The consideration of office objections is postponed. Pending that, the writ appeals will be listed on
Tuesday or Wednesday. Urgency, custody,
15th.
much of.
Serial number 46, my lord. Counsel for the appellant pays for time, my lord. He is going to hospital, my lord.
46.
Hospital, my lord.
46.
46, my lord. 46.
So what do you want?
I want 2 weeks time in that matter.
2 weeks time, stand at the request of learned appellants, stand over to
The meantime,
20th June.
in the meantime, my lord, interim order may be continued.
Interim order granted earlier shall continue to operate till the next.
My lord.
The arguing counsel is unwell. He is not able to attend the matter today. The same may kindly be 2 weeks may be granted.
At the request of learned advocate. You will be substituting your vakalat number? Will be appearing? Senior is not. At the request on behalf of the petitioner, stand over to after vacation.
I represent respondent. My lords may have it after vacation.
23rd of June, as requested.
Lord, serial number 32, my lord. Serial number 32.
32 years.
Lord, I appear for the petitioner. Lord, in respect of, Lord, this is a petition. Appeal. In respect of Slaughter's house, without permission, my lord, they have opened the Slaughter's house. Lord, because of that, my lord, it's an urgency, my lord. The arguing counsel, my lord, is in Dharwad now, my lord, in arguing the election petition matter. So, my lord, urgency is there, my lord.
My lord, appear for respondent number 13, my lords, and serial number 32.
Monday, my lord.
Arguing right now.
Lord, that arguing counsel is, my lord, is in.
You are also arguing counsel.
Venkatesh P. Dalwai, my lord. Venkatesh P. Dalwai.
So everybody is Venkatesh P. Dalwai. For us, everybody is same name. You know by same name that you are also Venkatesh P. Dalwai. All right. When do you want? 8th
Monday.
Monday, 8th.
8th.
Tuesday.
Please.
My lord.
36.
Serial number 94, my lord.
90?
94.
Oh, then all.
The matter is not reaching, my lord. Even on 26th, the case was.
Which one? Which one?
94, my lord. Officers raised objection on maintainability. May be taken on next week at 2:30 and it will not take more than 10 minutes, my lord. 94, serial number 94, my lord.
94.
Next
On
week.
compliance of office object.
No, this maintainability.
It is under that.
Thank you.
All right. When do you want?
Next week at 2:30.
Next week, 23rd will. 23rd of.
Much obliged.
36, my lord. We have been engaged in the Dharwad match.
Which one?
36, my lord. Kindly on Monday, my lord.
36. Engage for Dharwad. What is this matter?
It's regarding 321 CRPC, my lord. 321 of CRPC. Regarding withdrawal of cases.
Oh,
Was partly
when do you want?
Monday, my lord. My kindly.
Monday.
My lord, this is regarding serial number 41. This is refixation pension issue, my lord.
61.
41, my lord, 41. I retired in August 2013. Since then, I have been fighting. I am before this court since 2021. Now, a single judge order has been made.
41 is.
We want the early date. It is almost 11.5 years I have been fighting.
The state appeal.
Waiting for the justice.
Waiting for justice.
Yes, my lord. I retired on 31st August 2013, my lord. It is partially fixed, erroneously fixed. We are just before this honorable court for refixation of the pension. We want early date, my lord.
Any date you tell and will give it.
Maybe
Any
next
date you
week.
tell and will
Next
give.
week, my lord. Next week.
Tell the date, and since you are waiting for justice, we'll give earliest date.
21st.
22nd.
Yeah, okay, my lord. Yes.
No, you tell which date. We'll.
22nd.
22nd of June. April.
This month. Much obliged.
Serial number 110.
This is responded. Let it go tomorrow.
Tomorrow.
Because tomorrow, again it will go tomorrow. We have to rise it.
Yes.
Because of the reference.
Yes.
And
Tomorrow.
could your lordship have it on Monday, because there will be reconstitutional benches in the Fridays normally.
No, it will not take much time. There will be.
I am ready, my lord.
Will not. We have a whole day.
I may not be there, but let my learned friend complete that.
I'll go.
I think he'll take.
Tomorrow itself, tomorrow itself.
Then Monday.
Others, my learned friend is.
There is some.
Tomorrow your lordship may have it. I mean, if it's convenient to.
Some paucity of time tomorrow also.
Oh, then your lordship may have it on Monday, 2:30.
Monday
2:30.
Yes, my lord, I have a little difficulty on Monday.
No, you can continue on Wednesday. I'll finish it off because it's getting late. With some, I'll finish it off. You can continue on Monday. I mean, Tuesday. Monday, your lordship may have it. I'll finish it.
For my submissions, your lordship, I have it on Wednesday. Wednesday.
Fast.
Serial number 111. The Supreet CH, it's a withdrawal of contempt.
Figures on the record of the petition, memo dated 21/3/25, in which it is stated by the petitioner that the respondent has considered the claim of the complainant, complainant as petitioner. Therefore, the complainant is not inclined to proceed with the contempt proceedings and seeks permission to withdraw. The contempt petition is dismissed as withdrawn in view of the memo as aforesaid. Yes.
112 is disposed.
Lord, 113, I
For the
appear like to appear
complainants,
for
my
the
lord. My lord, they, the short
contempt now, my lord,
accommodation
the
may be
respondent.
granted.
Beyond vacation. 16th of June, as requested.
Look, could it be on the 21st, my lord? I'm coming from outstation. 21st, my lord, it will be convenient for me.
21st of this month?
This month, my lord.
No, it's not possible.
Then maybe any other date.
After vacation, 16th of June. We keep for your purpose early in special about 2:30. If you don't come, then we will not grant any nearer time. Yes.
114, stay and Srirab ready.
And for the complaint, my lord.
We have affected the revenue entries, my lords. They might confirm the same. On 25th of February, revenue entries as directed by the learned judge has been affected, my lord. 25th of February 2025. It is affected. Doesn't survive. That's my instruction. Yes.
Yes, my lord.
So entry mutation is affected.
Yes, it is reflected, my lord.
Then it doesn't survive. Learned additional government advocate, Mr. Chandrasekhar stated that the mutation entry is already effected in favor of the petitioner on 25th of February 2025. 25th of February 2024. Full stop. The spectrum of mutation was not disputed by learned advocate, Mr. So-and-so petitioner, who appeared through video conferencing in the aforesaid view. Nothing survives further. Nothing further survives in the present contempt petition. It is dismissed as not surviving.
Much obliged.
115.
To appeal for the respondent.
I'm for the petitioner, my lord. My lord, this case arises from a family court proceeding. Parties have taken divorce. In a consent proceeding, both the parties have agreed that the children will live. There are two children in the for the parties, my lord. Son is autistic and 15-year-old now. Daughter is about 13 years old, man. She is normal. The parties had agreed that each party will keep the children for 15 days each. Subsequent to the divorce, my lord, that proceeding continued, that process continued for some time. And thereafter, that was during the COVID time. And COVID time, my lord, as lordship is completely aware, people were not going out. Everyone was working from home. It was all good. But once the lockdown lifted, my lord, and the circumstances changed, the father started traveling outside the country. And during that time, the mother requested the father to leave the children with her. He doesn't do that. Subsequent to that, my lord, legal notices were sent requesting the father to come for mediation so that new terms can be discussed and agreed. That is not done, my lord. And the two children are United States citizens, my lord. Both the children are US citizens and they're living here. Living there? Living here, my lord, in Bangalore. Here. Yes, they're all in Bangalore. Lord, the father retains the child, my lord, by assaulting the mother on 2/4/2023. And thereafter, the father kept the male child, autistic child, and the mother had the custody of the female child. Notices were sent subsequently also to have mediation and to settle new terms. It was ignored completely, forcing the mother to file a petition, my lord, before the family court, requesting modification of the earlier consent order. Responding to that, the father appears in the court, and after hearing the parties, the learned family court makes some interim arrangements. My lord, that is found in page number 96, my lord, on 3/11/2023. Interim arrangement, my lord, is that through consent, my lord, both the councils and the parties and the court, my lord, directs that the female child will be sent to the father's home for the weekend. And then, my lord, subsequent order, the father concedes to send the male child to the mother's home for the weekend. This order, my lord, is finalized and by impugned order dated 12/1, my lord, on page number 99.
So which is the order which is continued at page 96?
Page 99 is the order, my lord.
Page 90.
Page 99 is the impugned order. Kindly see the last but one paragraph. Further, with the consensus of both parties, the visitation rights passed on 3/11/23 shall continue until further orders. Subsequent to this 3/11, my lord, kindly see the synopsis in page number 5. On 4/11/2023, my lord, the father complied, my lord. And from there, my lord, 18/11/2023 onwards, there is no compliance. The first act of contempt was on 3/11, willfully disobeyed. Second act, my lord, was on 2/12/23. Third was on 16/12. My lord, in this way, even when we gave legal notices, my lord, 2 legal notices were sent. He did not reply and he did not send the child. In the meantime, my lord, the mother was very diligently sending the girl child to the father's house as per the order, as per what she has agreed to, but the father was not sending. Subsequent to the filing of this contempt petition, my lord, orders were passed by the learned family court to hand over the custody of the male child to the mother. That has happened, my lord, in August 2024. This was filed in 2020, in July 2024, my lord.
So you are for mother,
I am for the mother, my lord.
and the custody of male child is with you.
With the mother now, by order of the court, my lord.
So that part is not under.
We are not, that is not under dispute. my lord.
Challenge,
They have
right.
challenged the order before the, which is before the learned single judge.
No, the custody of the male child
Yes,
to the mother
yes.
is not under challenge anymore. It
I'm
is
sorry,
not complaint of by the.
There's no complaint. It is with the mother now.
So now what remains?
My lord, the mother has custody of both the children now, my lord. Some visitation rights are being given to the father.
The other is a female daughter.
I'm sorry, my lord, I'm not able to hear.
The other child is a daughter.
Yes, my lord. The male child is autistic, my lord. He's 15. And the female child is 13, my lord. She is normal child.
So today she is in whose custody? She is in whose custody? Female
Both the
child.
children are with the mother, my lord.
So then what remains?
What is my lord, what we are looking for, my lord, is when this contempt petition was filed. At that time, my lord, there were 17 acts of contempt by the father who did not send the child to the mother in gross and willful disobedience of the orders of this honorable, of the learned trial court. We are on that, my lord. Subsequent compliance of an order passed subsequently on an application, my lord, will not erase or exonerate the past contempt of the contempt not. And my lord, such step for 1.5 years, if he has not complied with impunity, my lord. Even the learned family court judge was saying, comply with the order, but that was not complied with. Such type of impunity, my lord, and willful disobedience should not be tolerated. It goes against the majesty of this honorable court and the rule of law. We request after the petition was filed, reply affidavit was sought from the.
For the medical care of the male child.
It is being taken care of by the mother, my lord.
By both.
By mother. How?
When the child was with us, I was taking care of them. He was 14 or 15 years old. Subsequently, the respondent has.
Complaint is that you were denied visitation rights.
Yes.
For 1.5 years.
Yes.
Now, how the custody came to you?
No,
we have, the mother had filed an application, my lord, seeking modification
there was an
of
order
the
that I should hand over the
and
custody of
also
the child.
an interim application.
27/8, that is handed over. And since then, I have not been able to contact the son at all. And this order is modified, mother, by this honorable court. Can I pass on these to? The first order, page 4. This is the first order, not the. Page 15, this is the order passed by the family court. The petitioner at page 15, internal page 12. Much water has flown after on of all this. Child is handed over. Interim custody autistic is handed over, and it was handed over on 28/10/2020.
So today, which is the order?
Now, the latest order is, my lord, kindly have a look at page 23. That is the latest order passed by the honorable court, challenging this first order. Kindly have a look at page 23.
23 of?
Yeah, 23 of the compilation now, my lord, which I have passed on. Orders. Page 23, that is the order of this honorable court on 3/3/2025. This is made after hearing the children and the parties. Learned counsel of petitioner and learned counsel who are present before the court. The parties along with the minor children, so and so and so and so, are physically present before the court. This court has interacted with two minor children, a handsome boy and a young pretty girl. They are very well brought up and well-mannered children and are very talented in the field of cycling, swimming, and have good future prospects in their sports activities. This court appreciates the amount of time balanced by the mother as well as the father on their upbringing and concentrating on their physical and sports activity. Be that as it may, it is important for the children to spend quality time with the parents. Presently, it is stated that the girl child is having a national level cycling competition, which is coming up at the end of March 2025. Hence, this court is of the opinion that the same shall not be disturbed and the minor daughter shall remain with the mother so that she can participate in the practice sessions and compete with the event. Whereas the minor boy so is also in the care and custody of the mother. After interacting with the minor child, who is capable of deciding and doing things for himself, this court deems it appropriate to pass the following order. The petitioner father shall have the custody and visitation rights of minor child, Alan so-and-so, and shall pick up the minor child at 5 p.m. every Friday from the residence of the respondent mother at so-and-so, and hand over the child back to the custody of the respondent mother at the residence on Sunday at 6 p.m. The petitioner shall also have the custody visitation rights to the minor child every Sunday between 10 a.m. and 6 p.m. It is made clear that in the case of any delay from the minor girl child due to practice, buffer time shall be maintained by both the parties on flexibility. The other counsel for respondent shall communicate the message of picking up the minor child.
In this, the contempt petition, which is the order which is not compliant.
12/1/2024, my lord.
Much
Do not
water has
page-
flown. And
12/1,
yes.
just because much water has flown and
Correct.
few subsequent orders have been
What is-
passed, my lord, the
What is the
contempt is
vicarious
not washed
pleasure
away.
they get by sending
The
me to
contempt
jail?
is not washed.
After all, I am also.
Where is
I
that
also-
order? Page 100?
12, this is in 99, my lord.
99.
That order has not been complied with.
What does it say?
Says, my lord, further with the consensus of both the parties, the visitation rights passed on 3/11/23 shall continue until further orders.
Where
Those
is-
further orders, my lord,
Where is that visitation right? 3/11/20?
3/11, my lord, kindly see page number 95, my lord. It's actually a series of orders passed, my lord.
96.
95, my lord. Yeah, 95, my lord, 3/11/2023. It's on page 96.
Oh.
Kindly see fifth
Fifth
line, my lord.
Oh.
And the order passed by this court earlier has to be carried on, and after 2 months, depending upon the situation and development, the necessary order will be
So what is
passed.
that earlier? again?
Visitation during weekends in rotation.
Correct. What
That is on 27/10, my lord.
to send these
Kindly
on
see, my lord, page number 95 on top.
Saturday and
The
Sunday.
petitioner counsel has conceded, this is, my lord, petitioner is the husband, my lord, conceded to send son Ahan to the mother for weekend, Saturday and Sunday, and the petitioner agreed to send the child by 10 a.m. on Saturday, and the respondent undertaken to return the child by 7 p.m. on Sunday.
And how the custody of daughter is with you?
Custody of the daughter is, both the children, my lord, were with the mother.
Initially, both.
Initially, and then 15 days, it was happening, my lord.
So the visitation rights were granted in respect of the son.
We only for, this is for both the parties, since the children were separated, my lord. The mother had the custody of the girl child and the father had the custody of the male child. My lord, the learned trial court wanted to make it happen in such a way that the father gets to see the daughter every alternate weekend and mother gets to see the son every alternate weekend, my lord.
So thereafter, there was a compromise.
There was, through consent, consent it was
Son's
done.
custody went with the mother.
To the girls was with the mother, my lord.
Girl was already with the mother.
Yes.
Son's custody went to the mother after compromise.
No, my lord. After a judicial order in the IA number 10, my lord.
So what is the grievance now?
The grievance, my lord, is on the orders that were passed by the learned trial court on which is impugned order is dated 12/1/2024, my lord. The mother complied diligently, my lord, her share of the order in terms of sending the girl child diligently every alternate weekend as per the order, my lord. The father, with impunity, my lord, doesn't send the child to the mother. Absolutely, there was no communication. There was no way that the father sent the mother. Kindly see the synopsis, my lord. It is kept clearly. 13 acts of willful contempt, my lord, have happened
from the date of order till the date of filing, my lord. 13 acts of individual contempt.
So when the custody order was passed, custody.
13th August, my lord.
13th August.
Yes, my lord.
24. 24.
Yes, my lord.
So you are saying that from 12.
From there, my lord, the custody of the male child was transferred. Of course, he did not give the child. When we had to file an application for police support, then he handed over the child, my lord.
So you are saying that from 12/1/24 to 13/8/24.
Yes, my lord. That is the period when the contempt has happened, from 12/1 to 12/7.
There was also a case filed by her for domestic violence. Lord, there's an order passed by document number 2, which I have produced. Now, preventing me from even communicating, page 21 is the operative portion of that order of the criminal code, 16/1/2024. 21.
Where is the decree of the court pending on the
That is
custody?
compromise petition.
My lord, it is on Annexure A, my lord, page
Next-
36.
Annexure A.
Page 36 onwards, my lord.
So in the criminal court restrained me from communicating anything with the children or the wife.
The compromise
I can't-
petition in
one
Annexure
hand
A.
cannot hand over the children, and the other hand, there's a restraint order upon me.
So it was upon compromise.
Compromise. Then she has made an application to modify these terms also. That is pending.
After that, she did not send the children for almost
15 days, 15 days.
It is a
they
well
were
settled
supposed
law,
to-
my lord, by the Honorable Apex Court.
15
Several judgments are there which says
15
that
15 days.
subsequent orders compliance will not exonerate or wash away the contempt that was done earlier. And the surprising part, my lord, is that even after repeated undertakings before this honorable court, they'll file reply. They've not filed, my lord. But they are pursuing actively and
Son
aggressively
was not
a
ready.
writ petition
Child
that was
not
filed
ready.
to
Son was not
modify
ready
that.
to go there.
If you want us to go into, we'll decide. Today there is no.
Most of it, these are all small.
Disobedience is not small, my lord.
I mean,
Disobedience for 1.5 years continuously is definitely
the
not small.
child was not willing to go. That is one thing. Again, he was forced to go.
He's an
And the
autistic
daughter,
child.
again, she did not communicate anything with the daughter. They wanted my father wanted to see the daughter. She would not be coming. So I mean, there are two aspects of the same. You can say it one way, and the other also you can say it another way. I mean, these are human problems that they are, and we have to sit across the table and sort it out. It is not just that contempt that you go on trying to initiate and then making matters worse. And the husband has remarried now. He married a divorcee with a daughter. They are all living together. His parents, the second wife and the daughter, they are all living together. And according to my instructions, the second wife is taking care of the child very much. Lot of love and bestowed upon the child because he is slightly autistic, not fully, slightly autistic. So some small disabilities are there which they are trying to overcome. This is the case. This human problem that is there. I mean, it is not, you can't
The
be.
second wife is taking care of whom?
It's the son. Whenever he visited, he used to take care of the.
Whenever he visits.
Yes.
Whenever he visits.
Yes. And he doesn't want to go back. That is also a fact, Miller. He doesn't want to go back to the mother because according to my instructions,
That's a false
she is living with
statement,
somebody else.
That's a false statement.
You are enjoying visitation rights.
Tell me what?
You are enjoying the visitation rights also.
No, nothing is because I am prevented from even communicating with the children and the mother. This is the
false
order.
statement again, my lord.
No,
Lord, as per the order of the trial court, every 3 days video calls are.
Order, criminal court
It's a
order.
false
May I read the criminal court order at page 21? acting on section 18 also, respondent are hereby restrained from committing any act of domestic violence against petitioner,
It is
from
on the mother,
communicating
my
with the
lord.
petitioners in any form, oral or so.
That is not talking to the mother, not to the children. For the children, video calls are there every
No,
3 days.
on
It is
one hand,
happening.
I have to comply. The other hand, the court restrains me from even communicating.
The subject matter of this contempt petition is the study of two childs born out of the marriage of the parties who are now driven apart for their matrimonial disputes. Visitation rights were granted to father.
Yes, my lord.
In
Both.
In respect of son Ahan, aged 15 years.
Visitation rights were granted to the mother, my lord.
To the mother. In respect of son Ahan, aged
15 years.
Around 15 years now.
who is
At that time, it was,
autistic
yeah,
child.
at that time, it was 12, 13. My lord.
Similarly, the visitation rights of the daughter,
Of the
aged
daughter were granted to the mother, to the father, aged about 12 years now. At that time, around 10.
12 years were granted to the father. It appears that subsequently upon compromise arrived at between the parties, by order dated 13/8/24. The custody of son,
So that's not a compromise, my lord. That was judicial order.
but pursuant to
13
compromise.
13-8.
13-8
is a judicial order, my lord, on
That
IN.
was challenged before this honorable court, and that interim order which
So the
I was,
compromise.
no,
No, my lord.
it was a considered
That was
order
a
by
judicial
the
order on IN number 10.
IA number 10.
Some compromise was intended.
Consent order, this 12-1 impugned order is consent, through consent of parties, my lord.
Subsequently, by order dated 13/8/24, passed by the competent court, the custody of the son has gone to the mother.
Mother.
And the son presently, accordingly, stays with the mother. The daughter's custody was already with the mother.
Correct, my lord.
Full stop. The other side has no grievance about this status of custody, this status of custody of both the childs. However, the contempt is alleged by the petitioner mother that during the period from 12/1/24 till 13/8/24, mother refused to comply with.
Father
refused to comply with the directions to provide visitation rights to the mother, and that the male child was not sent to the mother.
Autistic male child.
When we queried the learned senior counsel as to whether, in light of subsequent developments, when the custody of both the childs are with the mother, and that the issue involves a delicate human relationship amongst minor children and the parents, whether the petitioner would still like to press the prayer for contempt, learned senior counsel for the petitioner respondent in affirmative to assert that it is a question of dignity of the court. Dignity of the court.
People have to obey the orders of this honorable court. My lord.
Dignity of the court and God-
Willful disobedience should never
We
be
are
a
saying-
rewarded.
We are not saying anything. We are only recording your submission. Dignity of the court. You use some word, therefore we are asking.
Majesty.
Majesty of the court. And that the orders of the court have to be complied with. Full stop. Contempt petition shall be notified for final hearing on 21st July.
Pleasure. June month or July?
4, again, 4, 4, the hearing can wait.
Pleasure.
Number 116.
Compliance affidavit is on record, my lords.
Nobody is there. None is
Lordship's
present.
orders dated 25/3/2025 may be looking to.
None is present for the petitioner. However, learned additional government Chandrasekhar states that the compliance affidavit is filed and the order is complied with in date we put up at 2:30 on 20.
On 25/3/2025, occasion was given to the complainant to be present, my lords.
Read that order, last one. This court has an occasion to pass the following order on 23/5/25. Then quote the order of 23/5/25. Today also none is present for the petitioner. Learned additional government advocate Chandrasekhar would submit that the endorsement since issued on 22/10/24, the representation of the petitioner is decided and the same is rejected, full stop. Undoubtedly, the aforesaid endorsement marks compliance of the directions of learned single judge. The contempt petition is disposed of not surviving. In case of genuine difficulty, however, it will be open for the petitioner to seek revival by filing a note.
If they are entitled.
Only for the reason that the counsel for the petition is not present.
Very much.
Since the counsel for the petition is not present today. Is not present. Yes, next.
117. Mr. Jay Prakash Reddy.
None is present for the petitioner. Stand over to 24th June. Yes.
Hundred and 18. Ranspreet Pritesh D'Souza.
Pertains to establishment of a tree authority throughout the state.
Which authority?
Tree authority, my lord.
Tree authority.
Yes.
So it is a mandate under the act.
My lord, I have received instructions. My lord, I'm with a memo, I'm filing the communication. My lord, they are requesting for 5 months.
Lord, our senior is not well.
If senior is not
Sir.
well, then who will appoint the tree authority? You are there. You don't want the tree authority to be appointed. You want or no? Then you argue.
Sir.
We can appoint tree authority without your senior. And you be instrumental in appointment. Yes, what is the memo?
My lord, they wanted
Give copy to
establish.
Pilgaus. See the memo.
My lord, the additional chief conservator of forests requests
Then
for
nothing survives.
5
nothing
months' time to complete the process of notifying the three authorities for all urban and rural areas. in
How
the
much
state.
time will it?
5 months, my lord, they are seeking.
In
If my
first-
lord could grant us, my lord, another grace period of 1 month, 6 months, my lord.
Why you need time to select the authority?
My lord,
Or to-
urban areas and rural areas.
They have to select.
Oh, my lord. List it for tomorrow, my lord. Senior will come. He's not well. Senior is not well. List it for
That
tomorrow.
senior is gone.
From past 3 days, he's not well, my lord. From past 3 days, he's not well, my lord.
You met him or not?
I met him, my lord.
Not well.
Not well.
When he will get well?
List it for tomorrow, my lord.
Tomorrow will get
Tomorrow,
well.
tomorrow he will come.
So shall we record that? Yes. Tomorrow at 2:30.
So blessed.
The memo submitted by learned additional government advocate is taken on record. Tomorrow at 2:30, in view of the request from learned advocate so and so, stating that learned senior advocate who is to conduct the petition is indisposed. Yes, ma'am. Next.
So 119.
Both 119 and 120 matters pertaining to deemed conversion under 95(9) of Land Revenue Act.
Yes, my lord, matters covered. Last date of hearing, it was given.
Pardon?
My lord, mandamus to consider the representation
under
for
9.
payment of conversion charges to the Deputy Commissioner Revenue.
Covered by judgment.
You passed some order.
Yes, my lord.
Not in this, my lords, covered by judgment.
That's
95.
95. Yes, yes. But this is PI
My lords,
Oh, my lord,
No, no.
my,
or disposed of?
both, my lords, 119 and 120.
19 what?
Bless.
You are Mr.
Sridhar.
Lord, your lordships had heard this matter, my lord. It is relating to the interim order, my lord, where there was a fraud classification. Your lordships had heard it, my lord, substantially. I'm told, my lord, that there is one development which has happened yesterday or today. The main ground on which, my lord, the learned single judge vacated the interim order was that the fraud classification has been removed now. In fact, in the writ petition, I had myself produced that letter also. But the learned judge, my lord, said subsequently removed, which was not subsequently, but anyway, on that ground, he did it. I'm told, my lord, that they've issued fresh notices to again put back the fraud notice. That is something which has happened, my lord. In the case of an associate company, they have received it.
Again, they have issued notices to treat it as fraudulent.
Continue the classification as fraud. So there is some, the B report is filed, my lord, by the police. And my case before the learned single judge was that they had first classified as a fraud without hearing me. Then they sent a police complaint. The police reported B report saying no offense is made out, it's a false complaint. Then, my lord, I filed a writ petition. Then they withdrew the fraud classification. I produced that also. Now that it's apparently they've issued one more notice. They'll have to place that, my lord, before your lordships.
That would anyway have no bearing on this matter, my lord, because this is a writ appeal against an interim order which was granted. If at all my learned friend client is aggrieved by a fresh attempt, then his remedies lie elsewhere.
Where is the interim order?
Your lordships will find the order, my lord, at page number 31. 31.
But in fact, a
Very
memo has
brief
been
order.
filed.
In fact, one of my main contentions, my lord, was that the learned judge did not look into anything. Any of the submissions made were not seen. Only on this ground, my lord, it was vacated. So very short.
This is factually correct submission was made, noting the facts.
No, no, it is not fact, my lord. The
Factually,
learned judge says it was subsequently removed. That was not correct. It was not removed after the interim order. It was removed, my lord. Prior to that, I produced those orders, my lord, at annexure L, page 155.
May I just point
The
out
order itself is produced by me. So may I make one request, my lord? There are all these facets of the case, my lord. If your lordships would see, my lord, I filed detailed objections to the application at page 227. There's no reference to it at all. Absolutely no consideration of any of the submissions that I made. So, my lord, if your lordship permits, I will go back to the learned single judge and renew my submission. Let the learned judge hear it de novo, my lord, because this is a very cryptic, non-speaking order, my lord. With due respect, I'm submitting. Honorable Supreme Court has said that if an interim order has to be vacated, there has to be a speaking order. Please see from page 227, my lord, my submissions. And the learned judge, under the mistaken impression that this fraud account was removed subsequently, vacates the order.
The order which is brought under challenge in this writ appeal, dated 19th December 24, is as under. Then quote the order, Sri Dhananjay Joshi, the start okay, stands vacated. Then not standard, released on 17/1/25. On the bare reading of the order, comma, and admittedly, comma, the order is interim order. Learned single judge hereby vacated the interim relief granted earlier on 28/11/24. Full stop, paragraph. The vacation of the interim relief was on the ground, as stated by learned single judge, that the petitioner's loan account, which was classified as fraudulent, and on the basis of which the interim order was passed, came to be declassified and stood declassified as not fraudulent, non-fraudulent. Full stop. There are more than one weighty reasons why the court is not inclined to entertain the present appeal.
Would a lordship's permit me to withdraw it then?
Withdraw. Learned advocate, learned senior Nagar.
With liberty, my lord, to move the learned judge.
Withdraw the appeal. Full stop. Permission is granted. The appeal is dismissed as withdrawn. Liberty is reserved for both the sides to raise all available contentions in law before learned single judge in the parent process.
Grateful.
This court does not express any opinion, however, on the merits of case of the any side. Interim applications stand disposed of in light of the disposal of the 9 appeal.
Here
For
for
the
the
appellant, my lord.
respondent.
Lord, on the last
Respondent number
previous
1.
occasion, the Lord was pleased to direct me to take notice to BBMP.
This is that.
This is where the sketch was made by BBMP, and in that, as per the place provided by BBMP, respondent 1, who is a person with disability, was permitted to put up a small shed for his livelihood. My lords may just see page 17, the sketch is there. Page 17.
In fact, my Lord wanted the stand to know what is the stand of BBMP. In fact, my Lord wanted to know what is the stand to be taken, which the BBMP will take in this matter.
I appear for respondent, BBMP, my lord. Now, my lord, after passing of this order, there is a development. My lord, this order was passed by the learned single judge, my lord, subject to government finalizing the rules. Now, my lord, with effect from 1/1/2025, Lord, the rules have been finalized by the government. May I
Where
just
it is-
pass on the,
Where it is status subject to finalize.
my lord, I'll just point out from the impugned order. Page, my lord, 20 of the writ appeal, ink page 20, my lord.
My lords may see, in fact, page 19.
No, you are saying that this order was subject to the rules to be finalized.
Yes, my lord.
The- No,
The
no,
petitioner-
that is at page 19.
Page 20, my lord.
19. However,
Transitory operation.
Operative portion of the order,
No,
class 2, my lord.
in fact,
The
before
petitioner would be
operative
entitled to this
portion-
use until 2024 rules are notified and the application filed by him in terms of such rules is considered.
Rules are not notified. What my friend is submitting, this is a rule draft calling for objections.
No, this is the final may I just pass-
Here it is saying that it is calling for objections.
No,
Let us see.
calling for objections is the previous rule, that is, my lord, dated 27/2024. This is, my lord, 1/1/2025.
You can ask him. The operative portion says on page 20
These are the
of-
final rules notified.
Yes, the final.
on, kindly see, my lords, at page 20, the operative portion of the order. May I just read out, my lords? Roman 2. The petitioner would be entitled to this use until the 2024 rules are notified and application filed by him in terms of such rules is considered. So what the impact of the Honorable Court was that at that time, there were no rules made for any allotment. And there were no rules in place. And applications have not even been called for. Now my friend is saying these rules are apparently notified. I have to now apply under the rules whenever they call for the notification. Whenever it is open for people to apply.
Then this order says that rule will apply whenever.
No, rule may apply, but the order says I have been given this place as a temporary measure. Even till date, I have not been allowed to put up the shed. This place will be given to me till whenever the new rules come, I apply under the rules and my application is considered.
All may apply.
No, all may apply. Of course, there is no difficulty in that. But what my only purport is, now my learned friend says rules have been notified. In these rules, whenever the applications are opened, I have to apply. And till the applications are considered, till then I have the protection of this.
No, core. Absolutely right.
No, core. Yes.
I'm sorry?
No, absolutely right.
Yes. So my submission is the application process, what my learned friend is saying, that if it is now called for, if the application process is opened, I have to apply. Till the applications are decided, I have the right to be here. That's all.
That's all correct.
Yes.
That's
So
the-
now even
Yes.
till date, I'm not allowed as per this order to even put up this 6x9 shop.
My lord,
No,
may
by-
I
this will
kindly
come.
take the next
By
portion.
tomorrow 11, you
Please.
find out the answer of the.
Yes, and I have to be allowed to put up the shop. He's having no
Lord,
livelihood.
kindly take
My
the
lords have
next
the
portion of the order.
reference,
Yeah.
of course.
That
Let
for
me take
tomorrow.
it tomorrow. Yes.
Please.
The commercial appeal,
No,
serial number 28 and 29. had
2:30, my
mentioned in
lords.
your lordship.
Two more at two.
Taken up at
Tomorrow.
2:30,
Two more at,
Tomorrow, 2:30,
2:30,
11.
11. Very good.
this will be 11. We'll first take.
Serial number,
Very
serial number
good.
45, lord. Serial number.
Now take that. We have
My lords,
Monday.
serial number-
Monday, madam.
Court officer.
28, 20.
Court officer.
2:30. 2:30.
Court officer.
Court officer.